Good morning. Good morning, ladies and gentlemen. You are welcome for this COE training in construction law. Involvement in construction law. We have distinguished gentlemen and ladies who have served this sector so well, and are going to educate us on those new developments. And feel free, when the time is right, ask questions where you don't understand. But let's give them the audience. We have Mr. John Kalemera. He's going to address us and is our first panelist to introduce the topic on procurement in construction law. He's a partner in Muhumuza, Kateva and Company Advocates. Please, Mr. John Kalemera, can you please take it up from here?
Thank you, Isaac, for that warm introduction. Just to give you a hint on why I'm handling procurement first, it's because before you have any construction contract, you must first go through a procurement process. Now, you can either have construction under what I will call private construction contracts, those which are not run by government, or you can have it under the government, which is what we'll call the public procurement. This presentation will mainly be focused on those which are handled by government, that is the construction of whether it is roads, buildings, and other infrastructure like bridges, because that is where the money is. And I'm sure most of the lawyers attending this session are interested in contracts where there is money. This is where most government expenditure goes, in works contracts. We are going to have, yes, just sharing the slides. I hope they are visible. We are going to have 5 topics tackled under this presentation. We'll have an overview of the public procurement process, dispute resolution procedures. The lawyers are engaged heavily in this process. We'll deal with the domestic contracts and the standard construction contracts. Finally, we'll briefly touch on international contracts. So before we understand what public procurement under construction contracts is, we would like to understand what or whom it applies to. It applies to all ministries of government, as well as statutory corporations and other entities. All these are defined in the PPDA Act. I can give you some examples. We have institutions such as UNRA, Uganda National Roads Authority, Civil Aviation Authority. We have Uganda Development Bank, Uganda Development Corporation. We have National Social Security Fund, and some institutions of higher learning, such as Makerere University, Muni University, and the like. So entities we call them PDEs, procuring and disposing entities. But for brevity, I shall refer to them as either PDEs or as entities. So these PDEs must purchase all their requirements in accordance with the PPDA Act and the regulations made under the Act. So that is what the procurement process is. It is the process through which these entities purchase their requirements. And it involves all the successive stages from the time the entity invites bidders to the time the bidders submit their bids, the bids are evaluated, the best bidder is identified, a contract is signed, and even the process of managing that contract. So just to make it clear, the procurement process does not stop when they have identified a bidder and the contract is signed. No, the procurement process extends all the way through until that provider or the previous, you are a bidder until you sign the contract. When you sign the contract, you're a provider. So until that provider has implemented, fully implemented the contract, then the procurement process is deemed to still be ongoing. So once the provider has fully implemented the contract, for example, in this case, we're dealing with construction. For construction, you will have what we call a defects liability period. That is after you've fully finished what you're supposed to do, you've handed over, the government institution has taken over and is now using whether it is the building, the road, the bridge, whatever, you have a period, usually it is 1 year, known as a defects liability period, during which you're supposed to remedy or correct any defects on that building or road or whatever. So until that 1 year is done, we consider that the procurement process is still ongoing. So when that 1 year is done, you have nothing more to do. All the monies are being paid. That's it. The procurement process has come to an end. There are 4 major types of procurement requirements. We have work, supplies, non-consultancy services, and consultant services. Today, we are going to be dealing with works. These PDEs, or institutions of government, which are defined as PDEs, are responsible for the management of all their procurement activities. In the past, we used to have one body responsible for undertaking all the procurements for government. It was the Central Tender Board, but now each institution is responsible for its own procurement process from the start to the end. This is to help you get an overview of the procurement process. It is much more detailed than this, but for ease of understanding, we can structure it and understand it in these 6 blocks. First, we start with initiation. The first step in any procurement process is when the user, the person who wants that requirement, if, for example, in UNRWA, there is a department which is responsible for constructing a certain road in Uganda, whether it is in Abim or somewhere, that department is going to make a request to the head of the institution, who is the accounting officer, going to request that, please, we need to start the procurement process for this road in Abim. That request is going to be in a prescribed form known as a Form 5. And it's going to have the particulars of what you require. That's such as construction of a road in Abim or construction of our proposed headquarters in Kampala, something like that. So that user sends it through their head of department, goes to the accounting officer. So the accounting officer is the top boss in the entity, the one responsible for making sure that these procurement processes go through smoothly, and the one responsible for approving that form. So once that accounting officer receives that form, the accounting officer confirms that the funding is available and then approves that requirement. At this point, the procurement process has been initiated. So once the accounting officer has done that, there is a structure within the entity known as the procurement and disposal unit. That unit is responsible for managing the whole process. And it is that unit which will pick that form and take it to the contracts committee for approval. The approval being sought here is for 3 things. Since the accounting officer has initiated the process, the PDU is going to take what we call a bidding document. This bidding document is one of the most important documents in a procurement process. It contains the full details of what the entity requires, the full details of what bidders are supposed to do while participating in the procurement process, the full details of how their bids will be evaluated. It contains a draft contract and the contract terms. So that bidding document is going to be placed before the contracts committee, as well as the proposed bidding methodology and a list of proposed members for the evaluation committee. This evaluation committee is the one that is responsible for looking at the bids and identifying the bid that will be the best evaluated bidder, who will take on the project and who will be awarded the contract. So once the CC approves this thing, the bidding document, the bidding methodology, and the evaluation committee, the procurement and disposal unit is now free to go ahead and issue a bid notice. That is the one inviting bidders. There are many types of notices. At times, there will be notices to a select group of bidders, but the one which is most preferred and most used is the open bidding method. And with this one, we have all bidders being invited. So that bid notice will be published in the newspaper. It's the one you usually see in the papers. New Vision you usually see on the front page, over 150 bids. So those are the bid notices that are being advertised. So the PDU will go ahead and prepare that bid notice and make sure that it's published in the newspapers. Once that bid notice is published, bidders have a period of give or take 2 weeks within which to prepare their bids, fully complying with the requirements in the bidding document. Now, when you receive that bid notice as a bidder, you're supposed to rush to the entity to pay for that bidding document, and then they give you a copy of that bidding document. If a friend of yours gives you a copy of the bidding document, you will not be allowed to participate. You must purchase it directly from the entity. I would just like to inform you that we also have electronic government procurement right now. And under this electronic government procurement, there is no manual paperwork. This bid notice, invitation, and everything is done electronically. But I can assure you that it's not being done by many entities right now. It's still in the pilot phase. So for now, it's mainly the manual as usual until the pilot phase for the electronic is done. So once the bidders have received the bid notice, purchase the bidding document, they go ahead and submit the bid within the time they have been told to submit it. If it tells you, if the bidding document tells you you're supposed to submit your bid by 11 a.m. on Thursday, the 3rd of November, 2022, and you submit it at 1 past 11 a.m., it will be rejected. So you must pay attention to those details as a bidder or as a person advising a bidder. Their timelines in the procurement process are very strict and they must be adhered to the letter. So once the bids have been submitted in time, the bids are opened before the bidders and certain information is read out, such as whether the bids have a bid security, the name of the bidder, and the amount of the bid price. So at this bid opening session, you will know how much your competitors have bidded. And in this case, some people start getting worried and start wondering whether they are going to last, because if you put a very high price, someone has put a lower price, some people immediately think that they're out, but that's not the case, because the evaluation is not done only on the bid price. There are other things that are considered, and you have to meet everything before the award you the contract. So we go to the evaluation stage. Once the bids have been received, the procurement and disposal unit makes sure that there is a sitting of the evaluation committee members who, as I had earlier mentioned, have already been approved by the CC. These members will have probably, depending on how complex the procurement is, they can have several sittings or they can have a few. So they look through the bid, each bid individually, and make sure that that bid meets the requirements of what was in the bidding document. So the bid which meets all the requirements and has the lowest price is the one that is going to be awarded the contract. However, these evaluation committee members are not allowed to evaluate using any criteria that is not provided for in the bidding document. There have been many cases in the PPD Appeals Tribunal emphasizing this fact. You cannot evaluate based on some criteria that is not in the bidding document. And this is also explicitly stated in the law. So once this committee has gone through the bids and it realizes that there's this one bidder who meets the requirements and the bid, he has the lowest bid price, they recommend the award of the contract to that bidder in an evaluation report, which is submitted to the contracts committee. We are now on block 5. So this contracts committee will receive that evaluation report, go through it, make sure that the law was followed when they were doing the evaluation process, and that there were no irregularities, because you know the country we are in, there is corruption here and there. So this contracts committee is supposed to act as a check and make sure that everything was done in accordance with the law and the bidding document. So once they approve that evaluation report and the recommendation to award to that bidder, they do what is called making an award decision. And now this award decision must be very clear. It must state 2 things. One, the contract committee is either going to approve the evaluation report and award the contract to bidder X at price X, or reject the contract and refer it back to the evaluation committee for certain reasons. Maybe they used criteria that was not there, or they wrongfully rejected based on what the bidding document had required. So they send it back to the evaluation committee to reevaluate based on their recommendations. So the tribunal has dealt with some cases where the contracts committee does not make a clear decision like that, where it either says we stay, something like that, we stay the process. Now, the PPD Appeals Tribunal has stated that contracts committee cannot make such decisions of staying or anything like that. They must be only 2 things. Either it approves the award or it rejects the recommendation of the evaluation committee. So these are some of the things you can also bear in mind when you're advising an entity, if you ever have that option. So once the contracts committee has made that award decision, a notice of best evaluated bidder is supposed to be issued within 5 working days. This notice is published on the notice board of the entity, and it is also sent to bidders. The notice states which bidder has been awarded the contract at what price, and it also states the bidders who are unsuccessful and the reasons why they were unsuccessful. After that notice has been issued, we usually have cases of bidders complaining. And this is what we call administrative review that we shall handle in the next slide. But let's assume there's no administrative review, there's no complaint. What happens after that is the contract, if it is above the sum of 200 million, it goes to the Solicitor General for approval. There's a constitutional instrument to this effect. All contracts above that sum, 200 million, are supposed to go to the Solicitor General for approval. And if the Solicitor General looks through and sees that everything is fine, the contract is good, Solicitor General gives clearance, and after that, the contract is signed, and we can now go to the next phase of implementation of the contract. In a nutshell, that is the procurement process. But like I said, even implementation is still part of the procurement process. We'll now go to the next stage, which is the dispute resolution procedure for bidders. There's only one dispute resolution procedure for bidders under the procurement laws, and this is a process known as administrative review. Now, there's a common misconception that a bidder can only complain about the procurement process when that notice of best evaluated bidder has been issued. That notice which says we are awarding the contract to bidder X at price X. No, that is not the case. A bidder can also complain at the stage when the bidder has purchased the bidding document from the entity. And this is because the procurement laws recognize a bidder as a person who is participating in a procurement process or intends to participate in a procurement process. So there have been a couple of cases before the PPD Appeals Tribunal and the accounting officer where bidders have challenged provisions in a bidding document on the grounds that either they have been drafted in a way to favor only one particular bidder, or they contain requirements which are extremely restrictive and cannot allow participation of other bidders. So the reason for complaining at this phase is if you don't complain at this phase when you have received the bidding document, you can't submit your bid and complain later, because the minute you submit your bid, it means you've accepted the terms and conditions, and two, you would be out of time because the law gives specific timelines for when you can complain. I shall refer to that later. So you can complain before the notice is issued, or the most common case is to have complaints after that notice has been issued. While they say bidder X is the best evaluated bidder at price X, that notice also contains the reasons why the other bidders were disqualified. So if you find that the reason given for disqualification of your bid is very unfair, say they say you did not submit a certain document, but you are certain you submitted it, you can lodge that complaint and challenge the decision. How do you challenge this decision? There are two tiers in the administrative review process. One, complaints must first be made to the accounting officer of the entity, that is the top boss in the entity. This accounting officer, look, I know some people wonder why you complain to the same person who has just failed your bid, but the same argument can be made about reviews in courts of law. A review is made before the same judicial officer who made the decision. But anyway, another aspect to this is that the people who made that decision to award the contract were the evaluation committee, which evaluated the bids, and the contracts committee, which made the decision. The argument is that the accounting officer was not really involved in the process, so he's in a good position to review your complaint and make a decision. So the first stage is you apply to the accounting officer. You're supposed to make this application within a certain period of time, which we shall discuss. And then if you're unhappy with that decision, you go to the PPD Appeals Tribunal. Those are the two phases, and one comes after the other. However, like you lawyers know, there are always exceptions. So in an exceptional case, if you feel that the accounting officer is conflicted or is impartial, you can make an application directly to the PPD Appeals Tribunal. However, this is in very exceptional cases, and you must only do this if you're very certain that you have facts that show that indeed the accounting officer would be impartial or that he is conflicted and cannot handle the complaint judicially rather. So one thing to note is that with this administrative review process, there is an automatic suspension. So in court, for you to suspend anything, you have to run to the registrar, get the interim order, and then you also have to have filed for a stay of execution and all those things, all those interlocutory remedies. However, with the administrative review process, Once you file your application with the accounting officer doesn't have a choice. The law requires the accounting officer to immediately suspend the procurement process. So the suspension is automatic and it runs throughout the administrative review period. That is the beauty about this process. How do you do it? How do you apply for administrative review? The application to the accounting officer is made by ordinary letter. It can be made even on the letterhead of the bidder or through the lawyers representing. I'll have to say that in most cases, the administrative reviews at accounting officer are made by the bidder, him or herself or itself. This is because they don't want to seem antagonistic and they don't want to seem like they're already engaged lawyers, they're ready to fight all the way. So normally they prefer that they will do it on their letterhead, even if they're represented by a lawyer. But for applications to the tribunal, there is a prescribed form in the tribunal procedure regulations, which you're supposed to use when making your administrative review complaint. There are some preconditions to make a complaint. When you're making a complaint to the accounting officer, one, it must be in writing. You can't meet the accounting officer in the hallway or at his home and say, no, me, I'm complaining. My bid was unfairly rejected. You have to put it in writing. Two, you must pay administrative review fees. And three, it must be made within the statutory period. I'm going to explain each of these, each of the other two preconditions. With regard to the payment of administrative review fees, there is a schedule in the administrative PPDA administrative review regulations of 2014, which provides for how much you pay. Now, it depends on the subject matter of procurement. Usually, works projects are pretty high. They have high sums. You'll find them in the region of 1 billion, 7 billion, 200 billion, and the like. Now, there is a scale starting from the lowest figure going all the way up to above 50 billion, different fees that you pay. I'll give an example. For 1 billion to 50 billion contracts, you pay 5 million shillings administrative review fees. The way you pay these fees is you can either get the account details from the entity, or you can pay by way of a banker's check addressed to the entity. The tribunal has held in many cases, I just gave an example of applications number 22 of 2021 and number 27 of 2022, that non-payment of administrative review fees is not fatal to your application. In other words, the fees can be assessed and paid later. And this came about as a result of entities at times refusing to give bidders the details of the bank accounts where to pay. And then the time runs out, and then the entity says you're out of time, you can't apply for administrative review. So this would prejudice many bidders. Now, the tribunal in those cases referred to high court decisions which hold the same view that failing to pay court filing fees is not fatal as long as you pay before judgment. So this was the basis for their decision that failing to pay fees is not fatal to your application. With regard to the other precondition of time is fatal. The law provides for timelines within which to file your application for administrative review. And the timeline starts running from the time you get to know or ought to have known of the facts giving rise to your complaint. For example, if it's the best evaluated bidder notice, if it is published on Monday, 5th Monday, then from the next day, because under the Interpretation Act, you start counting regarding time, you start counting on the next day. So from Tuesday, the next day, which is a Tuesday, you have 10 working days within which to file your application to the accounting officer from the date of publication of that notice of best evaluated bidder. So if you don't file it within those 10 working days, I assure you, your application will be thrown out either by the accounting officer, or if a bidder complains to the tribunal, by the tribunal. You must file within time. Similarly, if the accounting officer has made a decision, as a bidder, you have 10 days within which to complain. If you don't file within 10 days, and the law is tricky in this, when they amended the law, some parts have working days and others have just days. So at times bidders are thrown off guard and they think that the days are working days and they end up filing out of time. The application ends up being thrown out. So you must read this provision very clearly. It says days, use days. If it says working days, you have working days. I gave examples of the timelines, rather of the cases where this was held. We have numbers 8 of 2019, 1 of 2020, 18 of 2021, 26 of 2021, and 39 of 2020. So you can see very many decisions where they have found that failure to file in time is fatal. Appearances. Before the accounting officer, a bidder does not appear, or the bidder's representatives. You don't appear before the accounting officer. The accounting officer makes the decision on a documents-only basis. So they only look at what you've sent them in your application and other information they have available. They don't listen to the parties. But when you go before the tribunal, the PPD appeals tribunal, it will hear all the parties, either physically or by Zoom. These days they do it by Zoom hearings. So you appear before them, they hear you, and then they make their decision. Another thing to note about this process is from the decision of the tribunal, you can only appeal to the High Court. You can't go further. You can't appeal to Court of Appeal or upwards. There is a final appeal to the High Court, and you can only appeal on points of law, not on fact. Furthermore, at this stage, once you've gone to the High Court, that suspension that I talked about earlier is no longer there. So you have to apply for either it's an interim or a stay, and chances are it will be very hard to get those, because courts are of the view that procurement process should be allowed to proceed and during an appeal to the High Court. That's it on dispute resolution. We can now go into domestic contracts for works. There is no specific definition known as domestic contracts for works. I'm just using this definition to distinguish them from the other contracts which are not funded from the consolidated fund. The ones which are funded by the consolidated fund have to go through our local procurement procedures, the Act, and our standard bidding documents. There are two conditions before you sign a domestic contract for works. One, that administrative review period I talked about earlier, that is the 10 working days from the date that that notice of best evaluated bidder has been displayed, must have lapsed. And two, the accounting officer should confirm that there is funding before they sign a contract. Otherwise, they can get into trouble. The Public Finance Management Act prohibits them from committing government when there's no funding. Regarding that lapse of the 10 working day period, the reason why it's very vital is in the event that the entity goes ahead and signs a contract with the bidder, when that period of 10 working days from the date of the display of the notice of best evaluated bidder has not yet expired, that contract can be terminated, cancelled, whichever word you want to use. It can be cancelled once that is brought to the attention of the PPD Appeals Tribunal or to the court. And we have a case, Local Construction versus PPDA, where they cancelled the contract for breach of that standstill period. Get into the composition of the domestic contract for works. Now, ordinarily for private contracts, you just have just the contract itself, which is on about 5-6 pages at most, unless it's a bulky thing for works, maybe a bit more, but it's just the contract itself. But when we're dealing with contracts that stem from the procurement process, there are various other documents involved, which even include the contractor's bid. It's because the bid is the one that contains the contractor's bills of quantities. We have the contract agreements, we have the general conditions and special conditions of contract, which we'll briefly talk about later. We have the scope of works that is in the bidding document, the drawings, the completed schedules. So here you're going to look at various things. You look at the bidding document, the contractor's bid, the contract agreement. It's a whole buffet of things. These general conditions of contract, you will find them within the bidding document. They are standard. So the general conditions of contract in a contract for UNRWA, a local contract for UNRWA will be the same as those in a local contract for Civil Aviation Authority or for NADS or for any other institution. They run across as long as we're dealing with the works contracts. The general conditions of contracts are the same for works, and they're not supposed to be changed by the entity. They stipulate standard contractual terms, including things like how the disputes will be resolved, including things like when the contract will start and etc. But because they cannot give specifics for each entity, they don't know when the contract will start for contract A, or when it will start for contract B. These finer details are contained in special conditions of contract, which are also part of the bidding document. These special conditions will now give specific details about the location of the site, the start date, the intended completion date, and things like whether there will be advance payment or need for a performance security. Those are in the SCC. So what I've said is the GCCs are standard across all contracts in Uganda, but the SCCs have the finer details, and those ones are changed depending on the needs of the specific entity. Before a contract can be deemed effective, a construction contract can be deemed effective, there are certain preconditions. Most of them are going to require performance security to be issued by the provider who is successful, that is a successful bidder. Once you sign a contract, you're now a provider. So most contracts will require the provider to furnish the entity with a performance security, either a provider or a contractor. They'll require the contractor to also give an advance payment security. This is because for most construction contracts, which are above in the billions, that is, the bidders will normally require that they get an advance payment. That advance payment is necessary to do the mobilization, simple details, clearing the site and organizing to start the work. That advance payment, before it is given to you by an entity, you must give an advance payment security. So that in case you default, in case they give you that advance payment and you do not do the work you are supposed to do, then they can cash in your advance payment security and they don't have a total loss. Same thing with performance security. This one works for the entire duration of the contract. If at any phase it has been determined that you did not complete the contract as you are supposed to do, you are going to have your performance security cashed in and the entity will derive some benefit. Of course, the advance payment security and performance security are not the same in price as either the contract price or as the advance payment price, but they at least enable the entity to recover some money and not to make a total loss. One thing is the courts of law, high courts, in High Court Miscellaneous Application number 217 of 2022 and in Miscellaneous Application number 1 of 2021 have made some pronouncements on these types of securities. Once the entity determines that the contractor has breached provision which entitles them to cash in on either a performance security or an advance payment security, the entity is only obliged to write to the bank, say, person X breached as per these terms, please give us the money. And the bank, within 5 working days of verifying this fact with its records to make sure that indeed that provision was there in the security, is supposed to make the payment. The principle is pay first and argue later. So the bank is not supposed to wait for the other bidder, call the bidder, say, is it true? What? No. Once it receives that demand from the entity, it only verifies that indeed that term was provided for in the security, and it goes ahead to pay the entity. It is not supposed to do any further investigations. It's supposed to pay immediately. In those 2 cases, the bank did not pay immediately. The court went ahead to say that they breached, they're supposed to pay immediately. And secondly, the courts went on to say that lawyers should not file these interlocutory applications trying to prevent the payment of those securities. They say that those securities are supposed to be cashed on demand. That's why they are called demand securities. So basically, the courts have come out to say lawyers do not file interlocutory applications trying to prevent payment of an advance payment security or performance security. There are 2 types of domestic works contracts. There's a lump sum contract and an ad measurement contract. The lump sum contract will be for simple things. For example, if an entity has a building that it wants to renovate, it can have a lump sum contract, because here the deliverables are very clear to be seen, and you don't expect any unforeseen circumstances. However, if you're constructing a road, or even if you're going to construct a high-rise building and do some deep excavations within a small space, you do not know what's going to be down there. You do not know how hard it is going to be while you're undertaking those works. For the road, that one has so many unforeseen things. So those ones will be by ad measurement, and those are very common. With these ad measurement contracts, you are paid according to the work that you've done, using the unit rates in your BOQs. So according to your work plan, you'll be doing work in phases, and for specific phases, you'll be given an interim payment certificate, which those IPCs keep piling up as you go along. So you're paid for the work done, and these are the most common ad measurement. Sorry, I have to rush through time. We're doing a bit badly on time. There's some key government policies we need to take note of regarding domestic contracts for work. One is currently there's a circular from the Secretary to the Treasury that all contracts, including works contracts, must be priced in Uganda shillings. In the past, we had several being in dollars, and that affected the shilling. So now the circular is that all must be in Uganda shillings. The only exception is if the entity has been exempted by the Secretary to the Treasury, then it can go ahead and price in another currency. Two, we currently have a BUBU policy. I think many of you have heard about this, Buy Uganda, Build Uganda. And it has affected the way we conduct our procurements. Certain procurements have been reserved for what we call national and resident providers. A national provider is defined as one that is registered in Uganda and wholly owned and controlled by Ugandans. So if the company is incorporated here, its shareholding is fully controlled by Ugandans, it's considered a national provider. However, we have another arm. This is the resident provider. This is a provider that is not a national provider, which has been incorporated in Uganda for at least 2 years prior to the submission of a bid. Excuse me. My personal opinion is that this is a very weak standard, a resident provider, simply because I have incorporated my bid 2 years before you undertake your procurement process. That doesn't make me a resident provider. There should be a higher standard if you want locals to benefit. However, when they tried to make this more stringent, there was a lot of pushback. Investors went and met people in the highest offices, and they watered down this provision to only providers who were incorporated at least 2 years prior to bid submission. So for national and resident providers, there is we have what they call the local content guidelines. These guidelines were issued by the PPDA, and they provide that for public contracts for roadworks of 45 billion and below, they should go to national and resident providers. And contracts for other public works, such as government buildings, health centers, etc., basically buildings, those ones below 10 billion and below should go to the national and resident providers. Then again, even if the contract is above those two thresholds of 45 billion and 10 billion for roadworks and other works, still, if the bidder is a foreign provider, that bidder is obliged to subcontract a certain percentage, that is 30% of the value of the works, to national and resident providers. So you can see there is heavy local content being considered here. So even if you're a foreign, you're above the threshold and you participate as a foreign, they're required to subcontract 30% of those works to the national or resident providers. However, it has been noted that under the NDP3 that we currently have a very weak local content capacity. 80% of the works undertaken by foreign road construction companies. I think you've seen them, the CCCs, Railway Number 3, CCCos, but there are just so many Chinese construction companies. And they do very huge projects, but that's because they have the experience and we don't. In 2018-2019 financial year, only 28% of road contracts were given to local contractors. And again, it was not determining the value of these road contracts. They may have been of low value. The hope is that this NDP3 will increase local content participation. And like I said, we have some developments like the guidelines issued by PPDA, which encourage locals to participate. And there are also some projects which are being reserved for locals, like in terms of percentage of works to be done. We have the Ayago hydropower generation plant that is going to be given priority when it comes to local content. In the year 2019, the bidding document was amended to provide for some new features. Among them is the environmental, social health, and safety. One of the very prominent and established practitioners, Mr. Fred Milton, will take us through ESHS later on, but I can just give you a very brief outline of what this ESHS is all about. These are the environmental, social health, and safety provisions that are in that new bidding document. It's fairly new. It was issued in 2019. They provide for incorporation of environmental, social. Under the social, we have prevention of sexual exploitation, prevention of gender-based violence, and others. And we also have health and safety provisions. So entities are required to implement these provisions to the letter. They are not things that are optional. They are mandatory. They even affect the contractor's personnel. I shall explain how this comes in through the code of conduct. A code of conduct is supposed to be signed by contractors and by the contractor's personnel. And this is to make sure that they comply with the health and safety requirements, such as the PPEs, prevent sexual exploitation, because in the past, there were many cases of whether it is a foreign company or a local company, when they go to these remote areas, there will be very many cases of girls in the region being impregnated, getting AIDS and the like, and they were rampant in these areas. So communities were up in arms. There was a big uproar. So government had to come in and take steps and make sure that it holds the contractors liable. So the lawyers will understand the concept of vicarious liability. In the past, when we didn't have these provisions, the contractor would say, I am not responsible for what my staff does when they have stopped working. The minute they're done working, they go, they party, they do whatever they're doing. But now the rule is that these contractors are responsible for what their personnel does, even after office hours, as long as they are on site, because what they do affects the local populations. So those codes of conduct have to be in a language that is understandable by the workers of the contractor, because at times these workers are illiterate and other things. So they must be able to understand, and they must acknowledge that they have understood. So if there are any violations, the entity doesn't go looking out for the personnel. It goes and attacks the contractor and holds the contractor liable. Contractor pays fines. There's a certain security known as the environmental, social, health, and safety security. It can also be cash and other remedies. We're heading towards the end. We are now on international contracts for works. These are loosely referred to as international contracts, again, just to distinguish them from the others. Like I said, for the domestic, those ones, money is gotten from the consolidated fund. But for international, these ones are funded by international organizations. Common examples of these international organizations are like the World Bank, the African Development Bank, Islamic Development Bank. There's a French organization known as AFD. There's a German organization known as KfW. So under Section 4 of the Act, if there is a conflict between provisions in the Act and an agreement between Uganda and an international organization, the provisions of the agreement shall prevail. So normally, those funding agreements which are executed between Uganda and these international organizations that I've named provide that their rules and procedures, their procurement rules and procedures will be applicable. So the minute they do that, it means that we are not going to use our local SBDs and everything. We're going to use theirs. We're going to use their bidding documents and their contracts. So we'll be obligated to use theirs if it is provided for in the funding agreements. So their standard bidding documents contain the procedure for how the whole procurement process will be conducted, and they also contain the contractual documentation. Each one has its own. You will have a bidding document for African Development Bank, a bidding document for the World Bank, etc., etc. However, when it comes to contracts, these organizations usually prefer the use of the FIDIC contracts. Our esteemed colleague, Esther Kusima, is going to explain how these FIDIC contracts operate in the next session. I would like to just make it clear that in spite of the fact that these funding agreements provide for the application of their own rules, procurement rules, when it comes to dispute resolution procedures prior to contract signing, the reason why I say prior to contract signing is because after you sign the contract, in the contract, you usually find that the dispute resolution procedure is that you go for adjudication and then go for arbitration and the like. However, prior to contract signing, these bidding documents are silent. And the law, as it is now, is that we should use the administrative review process, which I referred to earlier, when handling even procurements funded by donors. And the tribunal has come out on this issue in applications number 3 of 2017, 5 of 2020, and 39 of 2022, to say that even if it's funded by a foreign organization and using their rules, because their rules do not provide for a dispute resolution mechanism that would conflict with ours, then we are supposed to use ours. We're supposed to use the administrative review process in the PPDA Act. Yeah, so the conditions of contracts, like I said earlier, will usually be stated in their bidding documents. For example, the World Bank in its GCCs refers to the application of the FIDIC Red Book. However, these details are going to be explained very elaborately by Ms. Esther Kusima in the next presentation. That brings us to the end. I thank you for your attention.
Thank you, John, for such an informative presentation. At this juncture, I would like to inquire from the participants whether they have any question, where they would seek clarity, and John is here with us to answer. You can also write those questions within the chat section of the app. So we await on you for questions. And as that is being done, allow me to also introduce our next speaker. As earlier I told you that this panel is made up of men and women of distinguished service in the construction sector, both professionally and practice-wise. So don't feel at home and ask any question. There is nothing off the limit for them. They have seen it all and they are willing to share from their heart. And our next presenter, speak at this ULS conference or training is Council Esther Kusima, Head of Contracts and Claims, Department, Uganda National Roads Authority. She's going to guide you on understanding FIDIC contracts. And as such, since time is also of the essence, as you get yourselves together for the questions, let's have Esther start off a presentation. We shall manage the questions along the way. Senior Counsel Esther Kusima, please, the floor is yours. The participants are ready for your presentation. Esther. Thank you.
Thank you very much. I request for some 5 minutes, please. You can have a 5 minutes break.
It's okay.
Thank you.
Okay, the participants, their questions, wait your questions. As the participants go on to formulate their questions, it's okay, you can write the questions in the chat room. We shall read them out for our presenter. Anything that you find needs clarification. As for my part, if John could clarify, because the PPDA tribunal seems to be in the same standing with that of, let's say, tax appeals tribunal. Should it be said that your right to appear before the tribunal is incumbent on the decision of the administrative officer, like we see in these other tribunals, more so other administrative tribunals like the tax appeals tribunal, where the commissioner's decision is standing on which you go to the tribunal either to challenge their decision. Is that the same with the PPDA tribunal?
Thank you for that, Isaac. It is, I would say it is the same to one extent, because like I said earlier, the way the administrative review works is it's two-tier staging. So first, the accounting officer must make a decision. You are grieved by that decision, and then you go ahead and complain to the tribunal about that decision. Or the accounting officer can even fail to make a decision after you applied to him or her, and then you go ahead and complain to the tribunal saying that, look, I filed, but they have failed to make a decision in time, or they have simply not made any decision at all, refused to accept my application. That is the first course, which is in line with what you've said. However, unlike the others, with the PPD Appeals Tribunal, if you feel that there is a conflict or impartiality on the part of the accounting officer, for example, if the accounting officer, him or herself, has made a decision on the very matter which you want to complain about. For example, there was a case in 2021. The parties were SMS Construction and another Turkish company against Ministry of Justice. In that case, the accounting officer had come out to perform certain actions, and the bidder was challenging those very actions which were performed by the accounting officer himself. Now, in that case, you didn't need to go to that same person because this person has already committed the offense and it's their issue that you're challenging. You go directly to the tribunal. So the bidder went directly to the tribunal and they allowed that in that exceptional case, they could come to them. It is indeed provided for in the law that if you feel that the accounting officer cannot be partial or that the accounting officer is conflicted, you can go directly to the tribunal. However, in most cases, you must only go to the tribunal after you have received a decision from the accounting officer, or the accounting officer has not issued a decision after they received the application. Thank you.
Thank you for that clarification, John. There is a question here as well for you that how has the current PPDA regime protected the growth of content, local content, looking at the factors of Build Uganda, support your Google more or less, buy Uganda, build Uganda. So the question is about that how is the current legal regime supporting local contractors to match up with those more experienced Chinese contractors?
Yeah, thank you for that. It is there are some baby steps that are being made. One of them is the introduction of that local content guideline from PPDA. I think it is guideline number 1 of 2018. So under this guideline, there are some contracts that are reserved for the locals. However, like I explained, it is debatable whether this is 100% effective, because the national and resident providers who are supposed to benefit from those contracts, the national fine is supposed to be someone fully owned and controlled by Ugandans, but the resident is referred to as a company which was incorporated in Uganda 2 years before bid submission. So I don't know whether this really satisfies. My personal opinion is that this may not truly satisfy the requirement of the local, because very many foreigners will come and operate their companies here 2 years prior to, they get aware of these contracts. 3 years from now, or whatever, they know some project will come up. So they come and incorporate a company and sit and wait. As long as it's done 2 years before bid submission, they will benefit the same way as you, a person who 100% has shareholding in a company and you're Ugandan, you'll be at the same standing. So in my opinion, it's not fully effective, but it is trying to be effective. So that is the first step. They have those local content guidelines where they've reserved contracts below a certain price to the national and resident. However, even those which are above the thresholds, and are being undertaken by foreign providers like the Chinese construction companies, they require that these Chinese construction companies, sorry to use the word Chinese, because it's not just Chinese, but they are the most we see. So even those companies are supposed to subcontract 30% of the work to the national and resident providers. So I think that one for me is the best one. So that once they subcontract that 30%, these nationals and residents, if they're serious, they'll pick up and learn how these people are doing the work, and as they become more involved and learn more from the experienced contractors, they can stop being subcontractors and start being main contractors. So that's how they're helping us. Thank you.
Someone is asking, how enforceable are those guidelines? More or less the 30%. How enforceable is it?
It is actually very enforceable, because these procurements that are being undertaken by the entities, they have to first of all be in a procurement plan. That procurement plan, you're going to state that I'm doing this and this contract, it's worth this amount, this and this amount, and we are going to provide for a reservation of 30%, blah, blah, blah. Then when you get that contract, when you are performing that procurement process as an entity, you're supposed to do what we call monthly reporting and quarterly reporting to the PPDA. That is the regulatory body that governs all the entities. That body is going to look at your reports and make sure that you're implementing these guidelines. It's going to make sure that indeed, for those projects being undertaken by foreign providers, 30% of the work is going to locals. If it sees that you're not doing that, you will be sanctioned as an entity. So entities are being compelled to enforce the provisions in the guidelines. Thank you.
Thank you for the enlightenment of that. Someone is seeking career guidance, that they have realized that John is very knowledgeable in the procurement area, more so on the construction issues. They're asking how can they grow their knowledge base in that area and also niche themselves as practitioners in niche. So please, as a final one, guide them, Mr. John Karimina.
Thank you for that one. Personally, I was able to benefit from my employment in the PPDA, that is the regulatory body governing all public procurements. My employment there is what helped me pick up this knowledge. But what you as a participant are doing right now, attending these sessions, this is the first step. You attend these sessions, and there are going to be many more to come of this type. These trainings will give you the knowledge which you can pick up on. There are also various programs on YouTube, Google Podcasts relating to these procurements, constructions, and etc. You listen and you learn a lot from them, as I usually do, because the things we do here are not much different from the things being done in the US and in the UK. The concepts are the same, the principles, they are really the same. So attend these trainings, you learn more and more. Thank you. Plus, I would just like to add that there are some specialized courses in places like UMI and UTAMU. If you want, you can also go for those. Thank you.
Thank you, John, so much for your enlightening presentation. All John has actually put to the end as he was trying to guide is that you must be interested, show up, and be intentional on what you want, and the rest will guide itself on the way. So don't sit back and wait to be an expert. People are putting some work and they are still putting in work. They are not resting. I would like at this juncture to call upon Madam Esther Kusima to start her presentation. As early as we requested for 5 minutes for each. So thank
Thank
you.
you very much. I'm trying to share my screen.
That is okay. As earlier introduced, Senior Counsel Esther Kusima as a head of Contracts and Claims Department, National Roads Authority. She's going to guide us on FIDIC contracts. And by the end of this discussion, her presentation, you'll be able to understand the input of the FIDIC contracts into the construction sector and why they are relevant for your practice and knowledge exposure. You can take it up from there.
Confirm whether you're able to see my screen.
Not yet.
Are you able to see my screen now?
Not yet.
And now?
It's on now. It's on.
Good morning, ladies and gentlemen of the Uganda Law Society.
Good morning. Esther, a minute. I'm requesting Mr. June Kalemera, if he could get to the Q&A section. There are some questions for him as Esther presents. You can answer them by typing. You can follow up. You can continue, Senior Counsel.
Thank you, Isaac. My name is Esther Kusima. As I've been introduced, I work with Uganda National Roads Authority in the Department of Contracts and Claims. I am going to present to you on the topic, Developments in Construction Law, a guide to understanding FIDIC contracts. Now, some of you may have heard about FIDIC contracts before and are wondering, what is FIDIC? You've probably heard about the different types of contracts, the red book, the yellow book. In this presentation, I'll make an attempt to explain to you what these are and how they work. I'll also want to emphasize the fact that a FIDIC contract is a contract like any other, which is subject to, what were they called? Were they called principles of contract? I can't remember. The offer acceptance and so forth, all those apply to a FIDIC contract. Oh, I'm failing to scroll. I'm failing to scroll. I don't know what's happening.
It is okay as you sort that at your end. You can have your PowerPoint presentation move within.
Okay.
Yes, it's now.
So this is what the presentation is like. We're going to look at what FIDIC is in detail, who may use the FIDIC conditions or terms of contract, when are they applicable, and why use FIDIC as opposed to drafting an ordinary contract. We'll also look at the various types of FIDIC contracts, the features of these contracts, and then we will look at the various parties to the FIDIC contracts. And then finally, we'll look at disputes. So this is what FIDIC is in full. FIDIC in English is the International Federation of Consulting Engineers, which is a body that brings together consulting engineers world over. And this body, I need to mention that Uganda's, I think it's called Uganda Association of Consulting Engineers, is a member of FIDIC. And so are other consulting engineering bodies from other countries all over the world. So this body has come together and has over the time developed standard forms of contract for application in certain types of contracts, as we're going to see. Over the time, these contracts have been refined with the latest revision to these contracts being, I think, 2017, if I'm not mistaken. And each update, attempts to correct errors that existed in the previous version to basically refine the contract and make it better in terms of, ease of application, fairness to the parties, and so forth. So the FIDIC contracts have been, as I've said, FIDIC is a very old institution. It was established, I think, in 1913. And since then, the standard contracts have been going, revision, update, and reform, and refining, basically, up to the point where we are now. And so they create a sort of predictable kind of contract. If you're a contractor in Germany and you know that there's a project in South Africa or a project in Uganda or Qatar, whatever part of the world, that is going to use a FIDIC standard form of contract, as an interested party, that alone would give you comfort, because you're able to anticipate what to expect in the contract. The contracts are fairly standard. The clauses have been applied and tested through the disputes and courts. And so parties can know what to expect in that kind of contracts. They can know what their risks are, even before entering into a contract. They can know what strategies to employ to mitigate risk. They would know, how work is supposed to be executed, how the dispute process is handled, and so forth. So these contracts create some sort of predictability in the contracting process. The nature of construction contracts is that they're usually large and high value, and therefore there's so much at stake. So if a person is going to, invest in this kind of contract, if I'm a contractor and I want to bid for work, I need to have, with some degree of certainty, knowledge of, what kind of risks I'm likely to encounter, what sort of profit margins I can make, what pricing strategy I could use, and all this would inform the preparation of the bid, the quotation of prices, and even proposals for how to execute the work. So FIDIC contracts increase transparency. They create some form of certainty, as I have explained, in contract implementation, and also ensure that there is more effective and proactive contract management and collaboration between the parties. The provisions of the contracts make it possible, for parties, for instance, to avoid certain things from happening, which would have cost the parties more money. Or if there's a dispute, the contracts provide for parties, to sit and talk and be able to sort out the dispute before it escalates to the stage where you would require an independent arbiter. These contracts are internationally recognized in the engineering space, and basically streamline the process of contract management, and, as I've explained, make it easy for parties to do work across borders. When you're getting into a new territory, a new country to do work, you need to familiarize yourself with the working environment. What are the laws like? What is the industrial practice in that area and so forth. But with FIDIC, because of their standard nature, their predictability, all these fears or risks are addressed. So these contracts may be used by any employer. An employer is a person that invites a contractor to come and undertake works. So it may be a private contractor, it may be a government institution, or whoever else wishes to undertake construction works. I forgot to mention that these FIDIC contracts are only applicable to works projects. So they could be a contract for provision of consultancy services for supervision of works, or it could be a contract for civil works to actually implement or do the construction. So we don't use these FIDIC contracts for other kinds of transactions. For instance, procurement of supplies, you would not use FIDIC. FIDIC is strictly for construction. The other advantage of these FIDIC contracts is that the different forms of contract, as we're going to see, are organized around the extent of design and other responsibilities assumed by the contractor. And what do we, both the employer and the contractor, what do we mean by this? That depending on how the parties have agreed, who is to design the works, is it the employer to, come up with a design for the works and hand it over to the contractor to implement? Or is it a case that you require the contractor to design the works, the employer approves, and then the contractor goes ahead to implement the works? We're going to see this in greater detail. Therefore, in determining the kind of contracts to use, the kind of FIDIC contract, you're guided by what your procurement strategy is. If the strategy is that I want a complete product, I don't want to suffer with doing designs, looking for a consultant to supervise, I just want a finished building, that then will decide what kind of FIDIC contract you're going to use. If it's a kind of contract where the employer is going to prepare the designs and then hand them over to the contractor to implement, that will also dictate the kind of FIDIC contract or FIDIC form of contract that one will apply. If it's a kind of contract where you're leaving the contractor to design the works and then to build them, subsequently construct, which we shall see later is called design and build contract. That too will also determine the FIDIC contract form that the parties shall opt to use. These contracts, because of their streamlined nature, predictable nature, are very attractive for where you have parties coming from different countries. You have, for instance, a project in Uganda, and you have a contractor coming from abroad. Once they know that you're going to use FIDIC, they're already familiar with these forms of contract. And so this helps a bit in allaying fears that the contractor may have with the risk of working in unfamiliar territory. Bidders are familiar with the clauses, and so this increases certainty and reduces risk, especially in developing, when the contractor is developing their pricing strategy. Now, because of the certainty that this standard form of contracts bring, this could also translate in lower prices, because the contractors understand generally what the risks involved in this kind of contracts are, and because of that, it may translate into a lower price. On the other hand, where a bidder is bidding in unfamiliar territory, they don't know what kind of contract you're using, they don't know what your kind of laws are. These fears are normally reflected in the price that the bidder is going to quote. A bidder will normally quote high to take care of any risks that may arise during contract implementation. But if these risks are known from the start, the bidder is able to take this into account when pricing. And therefore, because of the familiar nature of the FIDIC contracts, the prices may be a little lower than they would have otherwise been. So who are the parties to FIDI contracts? In a typical contract, in a typical works project, you normally have two types of contracts. One is a contract for supervision of the works, because when the works are being done for you as the employer or the owner of the work, you may not have the technical capacity to personally supervise the work. And so you engage a professional. So that contract between the employer and the professional who is supposed to, who is the employer's agent for purposes of supervision of the work, is called a consulting contract or construction supervision contract. The supervisor of this contract is a consultant. These two names, words are used interchangeably. The second contract is the contract for the construction of the works. And this one is not usually referred to as the civil works contract or the construction contract. So each of these two parties enters into a separate contract with the employer, as is demonstrated in this. So you can see there is an intersection between the employer and the engineer. And for that, this is called the supervision contract, as you can see the arrow on your right. And then there is a contract between the employer and the contractor for construction of the works. And that is a civil works contract or the construction contract. So each of these contracts spells out different responsibilities of the parties depending on the nature of the contract. Let's look at the roles of the parties to these contracts. The employer's role is to appoint the engineer. The engineer is the supervisor or supervising consultant. So this one is appointed by the engineer. For the institution I work for, UNRA, the engineer is not appointed. The engineer actually has to bid for the work. So we'll put out a tender and invite interested and qualified parties or consultants to bid. And then whoever is successful from the bidding process is then awarded the construction supervision contract. The other role of the employer is to grant access to the site. So the contractor is supposed to have unlimited access to sites. In the case of, there's a difference between the kind of work that we do at UNRA, which is the construction of roads, and other civil works contracts. For instance, construction of a dam or a building. Now, for a building, all that the employer needs to do is, grant. First of all, the site is in one location. You have an acre or 2 or 3 or whatever size of land, all in one place, and it's easy to hand it over. But for a road, the dynamics are different. You may have a 40-kilometer stretch of road, which goes through valleys, it goes through private property, it goes through mountains and so forth. So the dynamics here are different from a site for instance, construction of a building. For a road, you may have access to the first 4 kilometers. At kilometer 5, you have this very stubborn landowner who owns about maybe 300 meters of the portion that you want to take. 300 meters of his part of land touches the road corridor that you want to take. And this person is telling you, before you pay me a certain crazy amount of money, do not step on my land. And so you have a problem there. So kilometer 5 has a problem. Then you skip to 6, 7. You're going through a swamp or you're going through a forest. You can't touch it unless NEMA has given you approval. So granting access to site in a road construction project may not be as easy and straightforward as it is in the case of, for instance, access to site for construction of a building or a dam. If you're constructing a dam, the site is known, it is a specific site, and usually it is owned by government. If it's a dam over a river, the river can't be private property, it's owned by government, so that is easy to have access to. For a road, the dynamics are completely different. So the provisions of granting access to sites in a road construction contract may be slightly different from the provisions in a contract for construction of a building or any other civil works project. And normally what we do in our contracts, the employer guarantees that it will grant access to a certain continuous stretch, say 30 kilometers continuous stretch of land, and then the balance, the contract will provide for staggered granting of access. Now, failure to grant access has implications. It means that the project will be delayed. If the contractor has, for instance, constructed over the 30 kilometer stretch that was granted at the start of the contract, and then he reaches kilometer 31, and he finds that this landowner has in fact obtained an injunction from court, stopping anyone from stepping on his land until he has been paid. The contractor can't proceed. So what he'll do, he'll pack his equipment and wait, sit and wait. But meanwhile, each of those days that the equipment is idle and packed, the employer is paying so much money for that site. So that is the implication of failure to grant access. It also means that because you have delayed his progress of the work, that at the time when he ought to have completed implementation of the work, you're going to give him extra time to cover that period that he lost waiting for the employer to grant full access. The other responsibility of employer is to give instructions and notices, and these instructions are normally given to, not normally, they are by contract given to the employer, sorry, to the engineer or the consultant. The employer does not directly communicate with the contractor. Any communication that the employer needs to make to the contractor will usually go through the engineer or the consultant, who is the employer's agent on the project. The other responsibility is to approve certain actions of the engineer. Under the contract between the employer and the engineer, there are certain actions that the engineer cannot do without the employer's approval. For instance, any decision that is going to change the contract amount must be approved by the employer. Instructions to grant a variation of contract must be approved by the employer before it can be issued by the engineer or the consultant. The employer may also nominate subcontractors, certain kind of subcontractors. These ones are usually not subcontractors for the main works. They are usually subcontractors for support services. For instance, on each of these projects, they are normally smaller projects undertaken to do with social activities around the project. For instance, if you want to mitigate the spread of HIV/AIDS on these construction projects, which is a very big problem in these construction projects. Wherever there's a construction, you'll find, girls are getting pregnant, kids are dropping out of school to try and get onto these road projects and make a quick buck. People are getting infected with HIV/AIDS. And so to mitigate those risks, there are smaller, projects, contracts that are entered into with subcontractors to provide, for instance, HIV/AIDS services, management of gender-based violence, and so forth. So sometimes the contract may provide that the employer will nominate these subcontractors under the main project. The other major role is to make payments to the contractor for the works executed, and we're going to see about payment in detail, and then also undertake contract amendment when the need arises. On the other hand, the engineer's role or the supervision consultant's role is to act as the employer's representative on the project. So he's the face of the employer and stands in the shoes of the employer on the project. Then he also supervises the work that the contractor is undertaking, approving, the progress at each stage, carrying out tests, measuring work that is done, ordering repeat of work that has not been done in accordance with the contract, and so forth. In performing this role, the engineer is expected to be fair and independent and professional in doing this work. They're also expected to be impartial because they have a role or responsibility of determining disputes between the parties. So they are the first dispute settlement forum between the parties. When a dispute arises, you go to the engineer for him to make a determination. That is the first point. And many times disputes are resolved at that stage. Where there is failure by the engineer, there are remedies. The parties can appeal to, other fora as provided for in the contract, and we shall see this. The contractor is required to execute the works in accordance with the contract and in accordance with the work program that the contractor submits at the commencement of the execution of works, or as may be updated from time to time. They also execute the works in accordance with the engineer's instructions, because from time to time, there may be an instruction issued by the engineer to vary certain aspects of the work. And so the contractor has an obligation to follow the instructions of the engineer. They also have a duty to provide guarantees and securities, and we are going to look at these in detail. Now, these guarantees are varied in nature. They include the advance payment guarantee. If a contractor requires an advance payment is a payment that is done in advance of performance of the works. Now, under the law, under the PPDA law, an employer, and now I'm talking about government because the PPDA law will not apply in the case of private parties. A government institution is not supposed to make any payment in advance of performance. The only exception being made where if an advance payment guarantee for the full amount that is advanced has been provided to the employer. So if, and the contract will normally provide for this. So if the contract, for instance, has provided that you provide an advance, the employer provides the contractor with advance of say 10% of the contract amount, the contractor is expected to provide an advance payment guarantee of 10% of the contract amount. So he will go to his bank, the bank will prepare a guarantee, undertaking that in the event that the contractor has received this money and they have failed to use it for the purposes specified in the contract, the bank shall reimburse the employer with this same amount. So once that guarantee is provided to the employer, advance is then paid to the contractor. And advance is usually to allow the contractor undertake mobilization works. Now, mobilization involves setting up a camp. You've seen these contractors' camps around construction sites. You'll set up an office, set up a laboratory for conducting tests, and then also procurement of equipment to be used in performance of the works. The other kind of guarantee is a performance security, and this is provided to the entity to guarantee performance of the contractor. The amount is, at least in the case of UNRA, is usually 10%, but it may be any percentage amount as may be agreed by the parties. In the case of UNRA, it's 10% of the contract amount. The other guarantee is retention, and this retention varies well. In UNRA, it's about 5 to 10%. And its purpose is to give comfort to the employer that if there are any defects that arise with the works during the defects liability period, and you have called back the contractor to come and rectify these defects, and he has refused, you then have recourse to the retention guarantee. It is this money that the employer would use to undertake the works themselves, the remedial works. So that's the purpose of the performance guarantee. So in the case of UNRA, we only accept guarantees that are issued by banks that are domiciled in Uganda. Or if it is a foreign bank, we normally include in the guarantee a requirement that this foreign bank must have a corresponding bank here in Uganda that is willing to take on the liabilities of the contract of the issuing bank under the guarantee. In other words, you have a guarantee issued by Bank X in Kenya, for instance. That Bank X must have a bank here in Uganda that says, I agree that in the event that there is or the conditions for cashing of this guarantee have been fulfilled and a demand for payment of the guarantees made by the employer, I will pay this money on behalf of Bank X. So in that case, we'll accept the guarantee that has been issued by the foreign bank. It is a bit onerous for the contractor, especially if they're a foreign contractor. If they're a foreign contractor, they probably have a relationship with their home banks that can very easily issue them with these guarantees. And therefore, if you're requiring them to have a guarantee issued by a local company, it means they have to come, create a relationship here with a local bank for you to be able to issue them guarantees. So that creates a bit of difficulty on the part of the contractor. But on the part of the employer, there's a challenge that if you have been given this guarantee by a foreign bank and you've written to the bank to cash the security, the bank has jammed. You may not have so much control. You may not be able to, you may sue the bank, fine, and win. And then the challenge will be with enforcement of your judgment once you have succeeded. You don't want to get into all those. It becomes expensive to enforce the guarantee on the part of the employer. Whereas if it's a local bank here and the bank refuses to pay you, you don't even need to sue. All you need to do is write to Bank of Uganda and lodge a complaint against this bank. And Bank of Uganda will pick it up. In no time, the bank would have paid the guarantee. So for purposes of convenience of execution, we normally prefer that guarantees are issued by local banks, or if by a foreign bank, the foreign bank should have a corresponding bank here in Uganda that is willing to take on its liability. Then contractors are also required to provide insurance policies, and there are various types of insurance policies as listed below. Now we get to the FIDIC contracts themselves. There are about 6 different forms of contract issued by FIDIC. And we're going to look at this in the next few slides. The main difference being the question of risk apportionment between the employer and contractor. That's what distinguishes one form of contract from the other. The other aspect is to do with design, the risk of design. Who bears the risk of design? If it is the employer, then a certain type of contract would be appropriate. If it is the contractor that is doing the design work, a different type of contract would be appropriate. This is very important because many times during contract implementation, designs change. And when they change, there is a cost implication. And so the question is, who bears that risk for the change in design? And that answer that question is answered by determining what kind of contract you use, as we're going to see shortly. I'm going to place greatest emphasis on just 3 types of FIDIC forms of contract, because these are the most commonly used forms of contract, not just here in Uganda, but world over. That is the FIDIC Red Book. This is a graphical image of the book. There's a yellow book and the silver book. We'll start with the red book. And this is the most common type of FIDIC forms of contracts that is used for ordinary construction contracts, where the employer is the one that does the design of the works. So that is the difference between this red book and the others that we're going to see. For the red book, the works are designed by the employer. Now, this contract would usually follow the traditional, procurement route of you do the designs first. After the designs are ready, you then tender the work, for people to come and bid on the basis of your designs that the designs the employer has made. And then after bidding, the successful contractor will then build the works. Now, the typical features of this form of contract is that, as I've mentioned, the works or the design is owned by the employer. The works are designed by the employer, and the contractor's role is to implement the designs as instructed. So if you've designed your work and you've left out, you've omitted some aspect of the design, when construction starts, there has to be a variation of the designs. Now, when you vary, there's going to be a change in quantities, which may go up or down, and they may or may not be a cost implication from the change in design. The other feature is that the contractor is paid on a measurement basis for the actual quantities of work performed. John touched on this basically, but I would like to add that the kind of contract that you enter into under this red book is called an ad measurement contract, meaning when the bills of quantities were being done from the designs, you've designed the road. Okay, let me explain the process from first principles. Execution of a road project, and I will use road projects because this is, where I am comfortable. Execution of a road project starts with designing of the road. So a team of specialists will go out to the road, traverse the entire length of the road, study soil conditions. If there's a rock, all those aspects will be taken into account. Where the road is low-lying and needs to be raised a bit, that will be taken into account. Where the road is too high and needs to be cut a bit, all that is going to be taken into account in the design. And so from that design, you then develop bills of quantities. Because from that design, you're able to estimate and know that if I'm going to cut this section of the road, and then there's another section of the road which is low-lying, I need to get material to fill that section. If there's a section where there's a river crossing and you need to do some, they call it swamp treatment works. You've seen, for instance, people who use the Northern Bypass during its construction. You notice sections of the road where they had to pour a lot of hardcore to fill up the swamps before they pour marram and so forth. That's called swamp treatment. So all those quantities you have estimated, and then you've developed your bills of quantities. The bills of quantities are just an estimate. Now the actual quantities are what is actually executed. That is why you need to come back and measure. In your bills of quantities, you may have estimated that I need, for instance, 30,000 cubic meters of marram of a certain grade. You realize that from the designs that you were given, the swamp where you need to put a hardcore or marram is a lot deeper than you had anticipated. Therefore, you need more volume of hardcore, you need more volume of marram. Quantities are therefore increasing, estimated quantities. So at the end of the day, when that section is complete, the engineer and the contractor will come back and take measurements. And once those measurements are done, you then are able to establish the actual quantities. That is what we call the process of measurement. So parties come, do the measurement, and then from the quantities that you've ascertained, you compute how much is due to the contractor on the basis of unit rates that the contractor quoted in their bid. So a contractor will give you a standard rate and that will not change. They'll say, for instance, each cubic meter of marram, I will charge 10,000 shillings. So if in the bills of quantities that were issued at bidding, you've estimated 30,000 cubic meters, and then it turns out to be 70, you will apply 70,000 to the rate which is already in the contract, that is 10,000 per cubic meter, and then you'll derive the amount that is due to the contractor for that particular activity. That's the process of measurement. It's a bit tricky for a road, but more straightforward for projects like a building, because for a building, once you're out of the foundation is where you have uncertainties. You may be digging the foundation, you find there's a river under, and so you need to do some treatment there. Or you may find there's a rock that needs to be blasted and so forth. Or you may find soils are unstable, and so certain things have to be done to stabilize the soils. But once you're out of the foundation, the rest of the floors are more or less standard. the amount that it may take you to build the third floor may not be different from the amount that it will take you to build the fifth or sixth or seventh floors. It's more straightforward, but for a road, it's more complicated because site conditions vary along the road length. So that's the process of measurement. And that is done for this type of contracts where you're using the red book. The other feature is that the accepted contract amount is based on estimated quantities, and the final contract price is based on actual measured quantities. That's what I've just been explaining. That at the time of bidding and signing the contract amount is just an estimate that you have derived from the quantities in the bills of quantities. This amount may increase or reduce once the contract is completed. If you had estimated that you're going to use so much MARAM, and then after execution of the works, you realize that you didn't need all of it. The contractor has in fact not used all the MARAM. That is going to be taken into account when you're doing your measurement. And so you'll find the final contract price is much less or much lower than had been anticipated. So in the contract, you have what we call an accepted contract amount. That is the amount based on the estimates in the bills of quantities. And then the final contract price is the price after all the works have been completed, all the certificates are in, all the measurements have been done, and the final price is then computed. Now we go to the yellow book. The yellow book is normally used where works are designed by the contractor. By works, I mean, they may be, civil works or mechanical or electrical works, where the design responsibility is left to the contractor to do. And these are normally referred to as design and build contracts because the contractor designs and builds, whereas in the red book, as we've seen, the contractor only implements the employer's design. So this design and build contract is a lump sum contract. Lump sum meaning that, or I'll call it a fixed price, that the price that is quoted by the contractor in the contract is the contract price and shall not change. What does this mean for the contractor? It means that the contractor has to do a very good job when designing the work. If he leaves out anything, or if he has done a sloppy job, and then it turns out that, certain aspects of the design were left out. Remember, the employer has told you exactly what he wants. He said, I want a road which is of a certain thickness, which must be raised in low-lying areas so that it doesn't flood, which has pedestrian lanes and so forth. So the contractor goes back, sits down, and designs something that he thinks is appropriate to satisfy the needs of the contractor, and then attaches a price to it. So if there is anything along with the implementation of the contract which the contractor had not considered, that is the contractor's risk. Because the price is fixed, it doesn't change. Now, what that means is that the contractor is going to price much higher than you would have in a red book kind of contract to cater for that design risk. Because in this kind of contracts, you can never be 100% sure of what the conditions at the site are going to be. You can't, especially in the case of roads. You can never be. So the contractors will leave allowance for any unforeseen risks that may come up during contract implementation, so that that amount of money covers those risks and shields the contractor from incurring a loss. So you'll find that contracts which are executed using the design and build form of contracts are usually more expensive, much more expensive than contracts where the design is employers. However, on the part of the employer, it relieves them from that risk of the design. The risk is transferred to the contractor, and the contractor is going to charge the employer for taking on that risk of design. So a major feature of the yellow book form of contract is that the contractor bears the risk, the design risk basically. If there are any changes, the contractor bears the risk. However, there's provision in the contract that if there are any changes that result in a saving by the contractor, for instance, you had overestimated certain things, and then it turns out that the volumes are much less, there's provision in the contract for the parties to share the saving that is made. The other is the silver book. And this silver book is intended for use in what we call EPC contracts, the engineering, procurement, and construction projects or turnkey projects. The kind of projects where the employer says, I want an 8-story building with 4 floors. And then the contractor's role is to deliver the complete building. The employer is not going to come to, watch and see what you're doing. Well, he may have an agent there just to make sure things are going well, but the contractor will engage designers, will engage supervisors, and so forth. Do this project to completion and just hand over a complete or finished project, hand over keys literally to the project, to the employer. So in this case, the contractor is responsible for the engineering of the design, their procurement of the works, and then for their subsequent construction. In other words, the contractor provides, or he does whatever it takes to ensure that the project is complete and is able to hand over a finished project. You say, for instance, I want a school that has classroom blocks from P1 to P7, should provide an administration block, provide a chapel, provide a chapel mosque, provide a playground, and so forth. And all the employer wants is for you to come and say, the project is finished. This is the handover date. So in those kind of contracts, we normally use the silver book. And the typical features of this kind of form of contracts are certainty in the final price and completion date. Because as we have seen with the yellow book, this price of the EPC contract is also final. It will not change. Then most of the risk is allocated to the contractor. Certain risks are borne by the employer. For instance, the provision of site is employer's risk. Now, these contracts tend to be more expensive as just as the yellow book kind of contracts, design and build, because the contractor is making allowance for risks that may arise in this in execution of the works, considering that the price is fixed and will not change. The employer's risks may be to do with issues like war, terrorism, force majeure, and so forth. Isimba Dam is one of the projects that was executed using this kind of contract. Now we have the pink book. So these are other kinds, besides the 3 major ones I've talked about. There are other kinds of contract forms, and I'll briefly talk about this. One is the pink book. The pink book is a modification of the red book. It's used for implementation of works which are designed by the employer. This book was developed jointly by FIDIC together with multilateral development banks, or MDBs, and tailored specifically for projects which are funded by these banks, the World Bank, African Development Bank, and so forth, all the others. So certain provisions of the conditions of contract have been modified to suit this kind of contracts. Otherwise, this pink book is a very close mirror of the red book. It provides sample forms of contracts, sample contract forms for contract data, the particular conditions of contract, as we're going to see, templates of securities, bonds, guarantees, the dispute border agreements, and so forth. So this is just an improvement of the red book, and it is strictly used for projects that are financed by donors. So in this pink book, the contractor is still obliged to construct the works in accordance with the design that has been provided by the employer. So the employer still takes the design risk in this kind of contracts. The other forms of contract include the white book, which provides a model agreement for consultancy services. In UNRAP specifically, we've not been using the white book. For consultancy services, we normally use the template that is provided by PPDA. And so there's not been, in fact, I don't know of any contracts in UNRA where we have used the white book form of contract. The green book provides short forms of contracts, and it's recommended for use in contracts where the value is not so high. When you look at the user guide to the green book, it talks of contracts whose value does not exceed $500,000. Now in construction, in the construction sector, it's a very, very small project of $500,000, a very small project. This kind of contracts normally involve work that's repetitive and therefore, predictable. And then contracts that have a very short duration and do not require highly specialized subcontractors. And so because it's a simple form of contract, you may adopt the use of the green book templates. The gold book is used for design, build, and operate kind of projects, where in addition to designing and build, so basically this is an improvement of the yellow book on design and build. It also has the aspect of operating the project. We don't have, in the road sector, we don't have any of those kind of projects as yet. We have one coming up, the Kampala-Jinja Expressway. It's one of those where the contractor will have to design the works, construct, and then operate the works for a period of time. It's recommended for use where the operation period of the works after construction is at least 20 years and more. Yes, so that is when this gold book would be relevant. So in my practice at UNRA, we have not had opportunity to apply the gold book. So this is the typical project structure for a FIDIC kind of contract. You have the employer here at the top. And then the project may or may not be funded by external funders. Usually funding is from government of Uganda. Then under the project, you have a project manager who is usually staff of the institution. So in UNRA, we have engineers who perform this role of project manager. Then you have the engineer, who's the consultant we talked about, a specialist firm that is hired. They are permanently based on the project, watching what's happening every single day, taking records, measurements, and so forth. So that engineer reports directly, well, they report to the employer, but they have a working relationship with the project manager. So here from project manager to engineer, there should be a sort of dotted line. Then the employer also enters into a contract with the supervising consultant, which is the services contract here on your extreme left. And then this at the bottom on the left, we have the designers, you have the quantity surveyor and structure engineer. Now these ones, I have not put a direct line to either the employer or to the contractor, because depending on the nature of the contract, if it is a design, a contract where the employer is doing the design, then this will have a direct link with the employer. If it is a kind of contract where the design is the contractors, then this group here will then be on the right-hand side under the contractor. So between the employer and the contractor, you have the construction contract, where we're using here, in this case, we're using FIDIC forms of contract. And under the contractor, you may or may not have subcontractors, depending on the nature of the contracts, but they're usually subcontractors. You will not have all the work, especially in the case of roads, all the work being done, even for buildings. You may have a main contractor who's doing the actual construction works, but then you have mechanical works, for instance. You need to fix lifts, you need to do the sanitary fittings. All those will not be done by the contractor because that's not his specialization. You need to do electrical works. Plumbing, I think, is mechanical. Electrical works, you'll need a subcontractor to do the electrical works, or even to do the excavation of the ground and so forth. That one may not be done by the main contractor. that work may be subcontracted. So depending on the nature of a contract, you may or may not have subcontractors. So the contract itself contains the agreement. The agreement is usually about 2 pages, very brief, naming the parties, the contract amount, and the documents that are forming part of the contract. That is the information, and then a place for signature of the contract. So that is the agreement. Then you have the letter of acceptance of the contract. The entity must write the bid and say your bid was successful, and we're offering the contract, and the contractor must write back saying we accept. You remember principles of offer and acceptance. As I mentioned, they also apply in this kind of contracts. Then you have the conditions of contract, the general conditions, and this is where FIDIC comes in. FIDIC provides the general conditions. Then we have a section where the general conditions can be customized to suit the specific circumstances of the project. And that section is called the particular conditions of contract. So all those, the general conditions and particular conditions are together called the conditions of contract. FIDIC will only give you the general conditions, and then the parties at liberty to customize in a separate section called the particular conditions of contract. The contract also has the specifications, which could be the scope of work, the bills of quantities, etc. It also has drawings, since this is a works contract, and then schedules that may have, for instance, studies that have been undertaken in the project. For instance, materials, studies on materials for the sites and so forth, or investigations that have been done. Then there could be any other documents that are attached to the contract. For instance, you may have approvals. In the case of government contracts, you have approvals by, for instance, contracts committee. If it's a donor-funded project, you will have a letter of no objection by the donor. Other documents could be a power of attorney, a certificate of incorporation. It could be a certificate from a professional body, etc. So these contracts normally have, not normally, they all have a definition section which defines key terms as used in the contracts. Now this section is very, very important, especially when a dispute has arisen on the contract. You normally want to go back to the definition section to have a common understanding of a particular term as used in the contract. Now, the 2017 revision of FIDIC, the FIDIC documents, had some significant changes made to the definition section, and we need to be aware of this. They included new terms that were previously not defined in the older versions, the 1999, and other versions, to the certain versions of 2005, 2010, etc. And the failure to define these terms had created certain ambiguities, and in certain cases resulted in disputes. So 2017 has tried to address this problem, and you can go through the list. The list is long. I did not exhaust all the new definitions that are introduced by FIDIC 2017. Maybe also to mention that it's up to the parties to decide which version of the FIDIC conditions of contract they want to use for whatever reasons. Each version has advantages and disadvantages, and so the parties decide, and that is clearly indicated in the contract, the version of FIDIC that they're using. So I'll not go over these new definitions, but please, in free time, go through them. On commencement, the FIDIC form of contract requires the engineer to give a contractor at least 7 days notice of commencement of the contract. So the contract usually does not commence upon contract signature. Once the contract has been signed, the engineer has to make sure that everything is in place for parties to start before he can issue a commencement notice to the contractor. Then unless the parties have otherwise provided in the particular conditions of contract. Remember, I mentioned the particular code. This is the particular conditions of contract. I mentioned that this is the section where parties are free to, customize and change certain aspects of the general conditions to suit the specific contract. So the commencement date is normally provided for in the particular conditions of contract. And in case it has not been provided, FIDIC provides that the commencement shall be 42 days after the contractor has received the letter of acceptance. This commencement date is very, very important. It's a very important milestone date in the contract because of certain things as we're going to see. For instance, if a contractor is asking for extension of time, the extension of time must be completed from a certain date. If a contract is, say, 36 months, you need to know when the contract commenced for you to be able to compute the 36 months and know if you're going to grant the contractor extension of time, you know from which date you're extending. Then the contractor is required upon commencement, specifically within 28 days of receipt of the notice of commencement, to submit a program of works to the engineer. This program of works, as we're going to see, is also very, very an important document in the contract because it's on the basis of this program that the parties are able to know whether, for instance, the contractor is lagging behind in time, and therefore the engineer may have to take certain actions to push the contractor to work faster. Or if the contractor does not increase the speed, it means he's going to lose time. He will not be able to complete within time. And once he fails to complete within time, there are penalties that can be applied against him. So this program of works is very, very important. And the program of works keeps changing depending on developments that may emerge during contract implementation. If, for instance, there's been a COVID lockdown in the middle of implementation of a contract, and government has said people can't move, it means the contractor's staff cannot move to the site, and this is not a fault of his making. It also means that the contractor cannot easily, for instance, buy supplies that he requires. If he has to go and collect maram from 30 miles away from the site, movement is restricted, or at the point where he's supposed to get maram, there are no workers because people are not allowed to move. It means he can't progress with the work. So all those need to be taken into account, and the program may be accordingly adjusted. So the contracts normally have the general conditions of contract, and these general conditions, as I've said, are the conditions that are provided in the various FIDIC forms of contract, whether it's the red book, yellow book, the silver, or whichever other form of contract the parties have opted. They have standard general conditions, and they are normally, they were 20 conditions of contract. In 2017, the revision resulted in an additional condition of contract, and so in the 2017 version, there are 21 conditions of contract. So these are standard, they're standard conditions. In whatever part of the world you are, these don't change. Then we have the section for the particular conditions of contract. And this is a section that the parties customize to suit the uniqueness of the particular project. So there are certain aspects of the, parties may not be able to change every aspect of the general conditions, but the ones that you can change, there will be indication in the general conditions to tell you, for this one, the parties may otherwise provide in the particular conditions. So the parties may not choose to amend the general condition depending on what they agree. However, clauses that may be amended include clauses on access to site, the completion time, commencement dates, liquidated damages, percentage of retention, price adjustment, and many other clauses that the parties are able to customize. Now, with regard to time, time is very important in works contracts, because any delay by the contractor Any delay which is as a result of the fault of a contractor will result in a penalty on the contractor in the form of liquidated damages, also known as delay damages. They are charged for every day that the contractor delays to complete the works. Time is also important because a contractor is entitled to extension of time where there's an event of delay that extends the contract completion date. And that event is not a fault of the contractor. For instance, where the employer has issued a variation to the contract. During implementation, you realize, I'll give you typical examples of variations, for instance, on a road project, where you, for instance, had provided for a roundabout on a section of a road. Then you decide, instead of a roundabout, I'm going to do a grade separated junction. These junctions that have traffic lights, for instance, at Electoral Commission. So in the contractor's bid, he had bidded for a roundabout and he had done his costing on that basis. Now you've changed from a roundabout and you want a grade separated junction. That has cost implications. So the contractor has to do a proposal, cost it, and present it to the employer. Or he may actually go ahead and implement the works and then later on come and claim for the change. Other causes of extension of time include delayed access to site, where the employer was required to give the contractor access to site within a certain date, and the employer has failed to do so. That is going to delay the works of the contractor, and the contractor is entitled to recover that time. That time is given by way of extension of time for performance of the contract. And then I needed to explain that where the contract provides a completion date, this date does not mean that once the date has lapsed, the contract ends. If, for instance, we had a 2-year project supposed to be completed on 30th December 2022, when that date comes, the contract will not end. That's the nature of works contracts. Works contracts end when the parties have fulfilled their obligations under the contract, or if the contract is terminated. Otherwise, before the parties have fulfilled their obligations, the contract proceeds. This completion date is just a milestone date from which certain actions will follow. So if 30th December has come and the works are still outstanding, the parties will then ask themselves, whose fault is it that the works are not complete? Is it the employer's fault? If it is the employer's fault, the contractor is entitled to have that date extended. If it is the contractor's fault that the works are not complete, it means that the contractor is not entitled to have the completion date extended. And so for any day over and above the completion date that the contractor continues working, he's going to be penalized or charged liquidated damages up to a certain maximum that the parties may have agreed in the contract. So that's the implication of the completion date. It doesn't mean that after that date, the contractor has breached the contract. No, the parties will continue working as usual. However, if the contractor is entitled to extension of time, that date will be extended. If the contractor is not entitled to extension of time, for any day he continues working after that date, they shall be charged liquidated damages or delayed damages. With regard to contract price, the contract price will vary depending on the nature of contract, as I've explained. In the case of admeasured contracts, where the work that is done by the contractor is measured afterwards to ascertain the actual quantities executed, the actual price is determined after the works have been measured. And as I explained earlier, this price may be higher or lower than the price that was indicated in the contract at the point of commencement. In the case of lump sum contracts, the price is fixed, and so it is known from the start. These are the turnkey projects of the Silver Book, or the design and build code projects of the Yellow Book. So for these ones, the price is fixed. This price may or may not be subject to price adjustment depending on agreement of the parties. Under the PPDA law, it provides that for any contract that is to be executed beyond 18 months, the parties must provide for price adjustment. Price adjustment is intended to shield the contractor from changes that may happen, due to various factors. change in the rate of foreign currency, change inflation, because the presumption is that at the point of bidding, the contractor doesn't have control over the economy and over how things are going to go. And he can only, do a prediction up to a certain limit. So the law allows for him to predict the nature of prices up to 18 months. And beyond that, things are out of his control. So the parties are allowed to insert a price adjustment formula in the contract so that after that period agreed by the parties has lapsed 18 months, the parties have to go back and revise prices. Then payment for work is done by way of interim payment certificates. So the certificate will detail the work that has been done up to a certain stage. The engineer has to certify the certificates. He'll go back, do his measurements, computations, and so forth, and confirm that the amount is correct. And once they're certified, they're then sent to the employer for payment. Now, if there are any errors in the certificates, if, for instance, the contractor has been overpaid or underpaid, the contract allows that error or discrepancy in the certificates be adjusted in the subsequent certificate. So if there's been an overpayment in certificate 1, that overpayment may be rectified in certificate 2. Same if there's been an underpayment. Then the rates of a contract are usually fixed. But in particular circumstances, these rates may change. And FIDIC allows for change in rates. I think it is clause 14.8 of the FIDIC contracts. May allow for change in rates. And in that particular clause, it allows where change in rates where there has been a huge variation in the quantities. This is for admeasurement contracts. If you had anticipated that you, the example I gave earlier, you're going to need 30,000 cubic meters of gravel, and because of certain ground conditions that the parties had not anticipated, it turns out that you need 120,000. That is 4 times the amount, initial amount provided in the bills of quantities. In that case, the contractor under FIDIC is entitled to a new rate, to quote a new rate. Now, this section is a bit problematic because under PPDA, there's a provision, I think it's regulation 55 of the PPDA contracts regulations that says that if there's a change in quantities in the contract, the provider must use the same or lower rates than was quoted in the bid or provided in the contract. And yet FIDIC is saying the reverse, that if there's a change in quantities beyond a certain percentage, if actually FIDIC I think talks of 25%, if there's a more than 25% change in quantities, the contractor is entitled to a new rate. And when you read that provision of FIDIC, it is not very clear as to whether that new rate means a lower rate or a higher rate. But PPDA is more specific. It says the contractor either uses the same or lower rates. We've had a couple of disputes on that specific provision of change in rates. I will not go into the details of those disputes here. But for those interested, there is already jurisprudence on this issue. Let's look at claims. A claim is a demand for a legal remedy for which a party asserts a right. This definition is from the Black's Law Dictionary. However, in terms of construction, it's an assertion of a right usually by the contractor, but it could also be by the employer. The employer is also entitled to make a claim. And these claims by the contractor are normally for extension of time or to additional payment or both. So the claim is normally for extension of time, cost, or both extension of time and cost. Yes, they are provided for under subclause 8.4 of the FIDIC conditions of contract, as well as 20.1. This is where claims are provided for. So the contract is what forms the basis of any claim. And the entitlements and procedure for the claim are all provided for in the FIDIC terms of contract. So the FIDIC forms of contract provide for how a claim may be lodged. Important for us to note is the fact that there must be notice issued by the claimant within 28 days from the date the claimant first became aware or ought to have become aware of the circumstances that give rise to the claim. FIDIC goes ahead to say that if the claimant does not provide this 28 days notice, then they lose their right to claim. And the other party is discharged from any liability that may have arisen as a result of this specific claim event. So it is very, very important for parties to ensure that they give this notice to claim in accordance with the law. It must be within 28 days. These are the parties to a claim. It is the employer. The claim is usually by the contractor against the employer, or the reverse, the employer against the contractor. And then you have the engineer or the consultant, whose responsibility it is to determine the claims. So the claim is made to the engineer, and then the engineer will make a determination of the claim to the parties. So these are the matters that usually result in claims by the parties. Delayed access to sites, I've explained that. Variations, I've explained that. Delayed drawings. It is an obligation of the employer to issue drawings to the contractor, especially, yes, to issue drawings to the contractor. And so when these come late, they impact on the time for completion of the work. They may impact. And so in that case, the contractor is entitled to claim for extension of time or cost, or both. The other is unforeseeable physical conditions. You dig the ground to start construction, and then you encounter a huge rock, which requires the dynamite to blast it, plus NEMA clearance and all those other things that, one, cause a delay, but also may cause the contractor to incur additional cost. And so many other things. You may have underestimated the depth of a swamp. You may have underestimated stability of soils and so forth. Although you may dig up to a certain depth, the soils are stable. Below that, you realize the soils are not stable. Or you may have intended to lay your foundation on a rock. You've done measurements on the rock after taking samples and confirm that the rock is stable enough. When the actual construction starts, you realize that the particular parts of a rock that you never took samples from are not stable. So that changes everything. The other issue is idle equipment and manpower. The contractor has mobilized this equipment, he's mobilized staff on site ready to work, and you're not, as employer, not issuing instructions for whatever reason. And therefore, equipment and manpower is lying idle. Exceptionally adverse climate conditions. There's generally been a change in weather patterns in the recent years. And so, the certainty and predictability we previously had to know that, Uganda has 2 rainy seasons in March and then towards, I don't know when, September maybe, that may not apply. It's important to have this information because the bidders, in planning their works, take all this into account. They know, for instance, in March, I may not be able to do a lot of work, so they will not schedule to do a lot of work in March. But they know that in July, it's a dry season, and so that is the time that they would utilize the most to push a lot of work. And then come July, and the skies open up and rain non-stop. So that delays the works, progress of the works. And because the contractor can't work, his equipment is seated idle, the staff are seated idle. Some of the works are probably destroyed. He has done earthworks, he's dug up the ground, exposed the site, and then it rains, it washes away all that he has dug. He has to repeat the work. That is also a cause of a claim. He may claim for, additional time to redo the work. He may claim costs and so forth. Slow implementation by the contractor. And this particularly applies to the employer. In this case, the employer would be entitled to claim against the contractor. The employer has to issue a notice of intention to claim liquidated damages because of slow works by the contractor. And then acceleration or disruption of works. For instance, you have, say, Uganda is hosting the, what is it called, Africa Cup of Nations, and you need to build stadia. So you have engaged the contractor, and then you're told by CAF that initially the tournament was around June, so you've told the contractor the stadium must be ready by March. CAF suddenly writes and says, no, by January, we're sending a team to come and confirm that all facilities are ready and so forth, meaning that now you have to pull back the completion period. So you're going to push the contractor to increase work, increase his pace of implementation of the work. What does that mean? It means that he probably has to deploy additional staff, he has to deploy additional equipment, and all those come with additional costs. So he's going to claim for that additional cost that is incurring. It's important that a person who's lodging a claim substantiates it, and substantiation of a claim is normally by providing documentary evidence. So it's important during implementation of these contracts that parties keep documents, both the supervision consultant and the contractor. The contractor, in fact, both of these parties are required to have daily records of the site. They must record which equipment is on site and is in use, which equipment has broken down and is has been packed, how many staff were on site on every single day. All that information must be recorded, and that's the information that is used when making a claim and computing how much is actually due to the contractor in the claim. This follows the legal principle that he who claims must prove. If you claim and you're not able to substantiate your claim, the claim will fail. FIDIC provides for dispute resolution mechanism called the Dispute Adjudication Board. This, in the 2017 version, has been modified to the Dispute Avoidance and Adjudication Board. They've added avoidance because there's an additional responsibility placed on the dispute board to try and help the parties avoid a dispute when there are issues on the contract. So parties may refer matters to the DAB, including matters that have been decided by the engineer, for which the either party is not satisfied. So the DAB may hear complaints against, for instance, a decision issued by the engineer on a matter that had been referred to the engineer. The FIDIC forms of contract provide for appointment of dispute boards. The composition of dispute boards is under FIDIC. They're a bit selfish here. There is a FIDIC president's list of adjudicators. These are known world over. If you went to the FIDIC website, you can access this list. There are about 42 FIDIC certified adjudicators. So the composition of a dispute board is normally selected from the FIDIC president's list. For us as UNRA, we normally identify about 3-4 adjudicators and then request them to submit quotations. And then we do an evaluation and decide who the final adjudicator or the adjudicators will be. So the dispute board can either be a sole member, as may be provided in the contracts. The parties agree whether it will be a sole member or 3-member board. If it is a 3-member board, each party nominates 1 member, and then the 2 nominated will agree on the 3rd. And then the contract is entered between the contractor, the dispute board parties, and the employer. Remuneration for the DAB members is normally agreed upon by the party, and each party will pay half of the fees. Why would we use the dispute adjudication board? It's because they're involved in the project from the start. This board is not only called in when there's a dispute. They're actually supposed to, come and do periodic checks where they notice that there are issues that are likely to result in disagreement. They'll flag these and encourage the parties to address them so that they don't escalate to the point of a dispute. So their role is very, very important, much more than just dispute resolution. Parties may also refer matters to the dispute board for an opinion. If, for instance, parties are disagreed on interpretation of a clause of a contract, it may be referred to the DAB for an opinion. This opinion is not binding, but it helps to guide the parties, and it may sometimes result in resolution of a matter that could potentially become a dispute. Then they are cheaper than arbitration. Their fees are much less than arbitration. They resolve disputes faster. They don't have all these formalities that arbitration has, or even courts of law. They are much faster, and the time within which they are required to render a decision is prescribed in the FIDI contracts. It's 84 days from the time the matter is referred to them. And then important also to note is that these processes do not result in a stay of implementation of the works. And then they also bring some objectivity, because for them they're not in any way intimately connected with the contract, apart from the occasional visits where they come to check on progress and advise the parties, and then also if they're called in to arbitrate, adjudicating a matter in dispute between the parties. So these are the timelines for the dispute process. A claim, for a party to lodge a claim, they must have filed a notice. I talked about this. At least 28 days from the date the event, the party got to know of the event, the claim event. Yes, they file a notice to the engineer, and then eventually, after within 42 days, they must have filed a detailed claim with the engineer. And then the engineer makes a determination of the claim, and the engineer has 42 days within which to do this. If the parties are not satisfied with the engineer's determination, they can escalate the matter to the dispute adjudication board, which has 84 days within which to render its decision. Also to note that parties are allowed at any stage to engage in amicable settlement. So even if you file the claim with the engineer, or the claim has gone to the dispute board, nothing stops the parties from engaging in discussion and trying to resolve the matter at that level. And once it's done, you just simply need to notify the dispute board or engineer, as the case may be, that the matter has been resolved. So while parties don't agree with the decision of the DAB, they may then go for arbitration, and this is the final point of dispute resolution. With that, I come to the end of the presentation, and I will now take comments and questions. Thank you very much for your attention.
Thank you so much, Esther. I realized that we had set a timeline, but on realizing that the content you are giving is more or less a masterclass on FIDI contracts, I said, let me not disrupt the flow of knowledge. And it's well deserving, was rich and very helpful for those who are listening to a FIDI contract discussion for the first time. With your presentation, they are good to go. You touched more or less all the areas until the very end of the contract itself. So the contract structure, if they read it just after your presentation, they will not need much to get to know what this is all about. So, and considering the fact that this was done on short notice, thank you so much for the commitment, the zeal and the focus you have given to many that would want to join this sector. And start it off, I'm seeing so many people in the comment section thanking this presentation. It's been insightful. It's all thanks for you. I should say. I've not seen yet a question. Actually, the only question that is being asked here is that please tell Esther to at least in a few words to inspire people of your gender on how to feel safe and play within the male-dominated sector. It seems many feel like these men don't want them there, and they need to get comfort from you that this sector is for all, and anyone interested can play in it and survive in it.
Thank you very much. For those ladies out there who may be feeling that, this is a, sector reserved for the guys, I would like you to know that in the department in which I work, there were 6 ladies, there's no gentleman. We once had a gentleman who joined us, but he only lasted 2 weeks and opted to go to the department doing litigation. So it is possible for ladies to learn these things and create a niche in these things. You just have to have the interest. It's a very technical field of practice, but if you're interested, there's nothing that stops you. There are several courses available, and I can give you some pointers that you can undertake, but it's also very, very important that over and above acquiring the knowledge, that you actually practice these things. Try and interest yourselves in construction practice. There are lots of construction projects that are going on. If you can get those clients who are doing construction works, this would be a very good entry point for you to appreciate how this sector works, and getting to know all these things that I'm talking about. It's important that you actually practice. There is a master's in construction law available. Some of us here have done the master's in construction law, not myself, but I know a couple of colleagues in the Law Society who have undertaken this master's. But as I've said, over and above the training that you may acquire, it's important that you actually practice. Colleagues like David Kagwa are doing a lot of construction law practice. So you may want to have a chat with people like those, or actually come to UNRA. There are not so many entities that are doing construction law. UNRA, Ministry of Energy, entities under Ministry of Energy, UETCL, UEDCL, Ministry of Water and Environment also have a bit of construction projects. So this could be starting points for you to penetrate the sector. There are not so many people with this kind of expertise, so it's an area that would be good for lawyers to interest themselves in. But it's very doable. My department only has ladies. Thank you.
Thank you so much for that inspiration to our participants. Your moderator also happens to hold a master's in construction law and arbitration, and we have several others. Even your next presenter is an expert, but as I said, it doesn't add up to have knowledge in things you don't practice, because practice sharpens you and it proves the relevance for the knowledge you have. So focus, build, practice, and then if you can afford to get the paper, it is something that will be an added advantage. There is Mr. Edward Obo. Please, can you unmute yourself and ask your question? Edward Obo. We have Edward Dubo and Bukenya Kenneth Okumo. I'm waiting for them. Mr. Edward Dubo, if you can't speak, you can write your question.
Yes, that's what I was going to say, that you could type his question in the chat and then
Yes.
we'll respond to it.
In the chat, there's also a Q&A part of it. The Q&A, we have had an opportunity to answer some of the questions. There is Alan Baguma is asking, how does FIDIC compare with NEC contracts in terms of usability and quality? Esther, that is your question. How does FIDIC compare with NEC contracts in terms of usability and quality? That's from Alan Baguma in the Q&A section.
I must confess, I'm not very familiar with the NEC contracts, and so I'm not in position to do the comparison. But if there is anyone amongst us who is familiar with the operation of a NEC contract, they may be able to respond to this question.
Milton, this goes to you.
I also see there's a question on whether the EU legislation allows this. The question is not very clear.
That question it's a follow-up on some other discussion within the chat.
Okay.
Yes, it's a chat. Mr. Milton Fredo Chen, even though your presentation is next, is there a way you can help us on this? Sir Milton, come out, unmute yourself, and you help in this discussion. But as Milton comes, I'll need to say that NEC and FIDIC contracts, as also we have some other types of contracts that have been formulated by okay. Milton will also deal with that later as he comes to address us. But for me, on my part, let me try to give you the basic of it. You see, some of these contracts, the standard contracts, FIDIC and NEC are all standardized kind of contracts for this built environment. And the usability is dependent on what you are conversant with. And oftentimes the English and some of the EU, where there is not much of the donor funding, they will use their NEC, and it's a bit different from us here in our continent, where we are relying so much on World Bank. And FIDIC happens to be the contract of choice by the World Bank. They even have more of a World Bank engagement where they sign contracts that these contracts, FIDIC contracts, shall be used in all projects funded by the World Bank. It happens to even be used by our other donor entities that are helping our infrastructure. So FIDIC, that's why it comes out so much in this part of the world, because many of our donors or funders prefer that type of contract. You can only get a comparison where it is more of you choosing. But if you compare both, you will actually get to realize that they move in tandem. They are trying to be responsive to the industry demands. What FIDIC puts in as a new development, you'll get to see even the others like JCT also incorporating. So they are more of just a matter of choice that you choose to go with this one or the other. But usability would be on the legal liability they are trying to protect you from. And there are all terms of contracts that are protecting the same subject matter, the same technical conditions. So don't try to get into the argument, this is better. No. What is best is your client's interest protected, and the rest will be history. Mr. Baguma, yes.
Oh, Isaac, let me just to top up on what you've said. They are all standard form contracts to begin with. Of course, if we are to compare, one, from a technical point of view, is that NEC particularly is designed to manage projects mostly of a civil engineering nature, as opposed to FIDIC, which is wide and as explained, ably explained by my sister Esther. The key thing with NECs is that it's mostly for preventing costly disputes. They focus more on looking at an engineering project with a view that how do we resolve disputes? How do we ensure that disputes are resolved and and prevented at the cheapest cost possible? And that is why the other key difference in terms of comparison is that NEC is a champion, for example, of early warning notices. If you read that contract clearly, you see they emphasize a lot that before a dispute goes bad, there are early warning notices that have to apply. These are all made, to ensure that a dispute is avoided at all costs possible, with the exception that where you cannot avoid a dispute, it will definitely happen. The other thing is, the other point would be usage. FIDIC is a champion globally. Esther has already explained when it started in so many years ago, and consulting engineers world over use it a lot. And so with engineering projects as well, construction projects, it has been accepted a lot, widely accepted at a global scale. That is why UNRWA, for instance, for most of their road projects, they're using the Yellow Book, is where they're doing design and build. And also, even for consultancy purposes, sometimes they try to marry the two. But my point is that FIDIC is generally used, it is more friendly. FIDIC has committees on, there are special committees under FIDIC where experts, the consulting engineers meet time and again. I think they do not take more than a year before they meet to be able to review. For example, they have unleashed the 2017 module. They're already on the ground trying to, is it working, is it not working? Because the 1999 model edition is still very popular. In the Middle East, where I've done some practice, they are still so much rigid on the 1987 edition. So FIDIC has this mechanism of reviewing and reviewing. And if you open a FIDIC contract, the explanatory notes which and usability of the contract, so that if you want to adopt the FIDIC and you want to modify it, there are instructions which are part of it for you to easily, if you're coming up with a tailor-made or a modified, so that you don't mess up the clauses. That is what I can say quickly about that. Thank you.
Thank you so much, Milton. Please prepare for, be ready in the next few. And Mr. Baguma seems satisfied with your answer. He's thankful. If there is any other question, please, this is the time. We have Esther, but even within the chat, keep those questions coming for my senior counsel Esther for them to be addressed, because until sometime next year, you may not have access to her. This is a golden opportunity. And this kind of knowledge comes at a very high cost. So please utilize the opportunity, seek clarity. It might turn your client's case around. Our next presenter is a Mr. Milton Fredo Cheng, partner, Milton Advocates. He also happens to be our Uganda Law Society representative to the National Building Review Board, where he's serving our interests ably. And in his last presentation, we have had him speak technically about certain pertinent types of contracts. He holds special training in construction law as well as engineering, so that he can easily relate. He's an expert. He has litigated and also has done arbitrations on this area of the law. So the person coming to talk to you about safety health and safety in construction sector comes with a wealth of knowledge, comes with practice and regulatory knowledge as well. Because as a board member of the Building Review Board, on day-to-day basis, they are trying to see how safe are our construction sites, how safe are our buildings in occupational standards, if utilized well, and they have really put a mark on how works should be done. They are laboring to improve the sector, and he's contributing that with the best interests of members of Uganda Law Society. So he's the best person to even expose you on how you as a lawyer, you can position yourself with the Uganda Law Society. And this gentleman just told me he needs a bit of 5 minutes to get himself ready so the questions can keep coming. I needed the other question by Esther was to Miss June Kalimera, and it's something in the chat. Please bring up your questions. We have a very able panel of experts that will answer. Mr. Edward Obu, please come back. And Mr. Kalimera is online, available, and also Madam Senior Counsel is also available for your any questions you have. Please don't be shy. It is a learning experience. This is why they call it continuing legal education. Continuing legal education to improve ourselves. Madam Esther, Council Esther, someone is here asking, and they are wondering that what kind of expertise would you use? Is there, and actually, I think, is there any other form of contract other than that? Are there times when UNRA uses bespoke contracts? Contracts, I think, developed internally other than these finished contracts.
Thank you. We don't use contracts developed internally. Now, we have two types of projects, contracts. There are contracts or projects that are funded by Government of Uganda. Now, for those contracts, we are by law required to use the standard form contracts developed by PPDA. Those are available on the PPDA website. So for Government of Uganda projects, we use PPDA standard form contracts. For contracts that are funded by donors, or for contracts that are funded by Government of Uganda, but for large works, we use the FIDIC standard FIDIC form of contracts. Now, FIDIC form of contracts, as I explained, have been developed over the years and known world over, create a certain certainty and comfort to the contractors. And for all those reasons that I talked about, bidders are more comfortable when we use those kind of contracts. For Government of Uganda projects, they are normally straightforward, simple projects. We normally use them for maintenance works. You know, you already have an existing road that requires, for instance, putting a fresh layer of gravel, or sorry, a fresh layer of tarmac. That's not a very complicated contract, and so may not require the use of FIDIC. In that case, we'll use PPDA. or if it is a contract for construction of a bridge is fairly standard. It's like a construction of a building that once you've done the foundation out of the water, the rest of the structure is like a building. So that one is fairly simple to do. In that case, still will use the PPDA form of contract, or if it's one of those where you require the contractor, actually it's usually the case, you require the contractor to design the project, then we'll use the design and build. So for most of our bridges, executed using design and build. For road maintenance, all these upcountry gravel roads, you know, a contractor will come grade the roads, insert new culverts, do a bit of swamp treatment. Those ones are basic. The work involved is not complicated, so PPDA will suffice. But the high value contracts, where road conditions are generally varied, the amount involved is a lot. You may have a project, for instance, for construction of a road, but as part of that project, you need to do a bridge. I don't know how many of us have used the Masindi Kisanja Park Junction Road connecting to the northwest. You will notice that after the Masindi Park, there is a bridge, Para Bridge, connecting the Masindi side to the northwest. That is a huge, huge project. They need to do the road, but there's also that aspect of the bridge over River Nile. You cannot afford to use a PPDA contract in that case because it's very complicated. The risks are high, and so it's better to use, you know, FIDIC that is more detailed, is better known to the contractors, and so in that case, we would use the FIDIC contract even though the project may be funded by Government of Uganda. Otherwise, for all the donor projects, we use FIDIC standard form of contracts. Apart from EU has their own form of contracts that is different. It's not FIDIC. And so if the project is funded by EU, we'll use the EU standard template, standard contract template. I don't know if that answers the question.
It does answer the question. Thank you so much. There is a question from Esther in the chat itself, Q&A. She's saying, thank you, Esther, for the presentation. How do you manage escalation costs caused by delays to grant access to the contractor and unforeseen circumstances during implementation? These costs can overwhelm a project.
Thank you. For unforeseen circumstances, there may not be much that you can do to manage them because the circumstances are unforeseen. It's not anyone's fault. So in that case, the best advice I would give is to, you know, try and manage the time within which the circumstances are addressed. The longer you take, the more costly it becomes for the employer. Otherwise, you may not have control over these circumstances because no one has anticipated. Then the other case was, sorry, let me make reference to the chat again. Oh, delays to grant access. That is completely within the employer's control. The contractor cannot do much about this. It is the employer's responsibility to grant access. There's been a school of thought that maybe there is need to create a government agency whose responsibility is just to acquire land for execution of government projects. So that will then free the government entity to concentrate on the project itself. Because for us as UNRA now, we have a whole department that is doing land acquisition. And yet we're depending on several agencies of government. You're depending on Ministry of Land, you're depending on the Department of Mapping and Surveys in Entebbe to sort out all these issues. You're depending on the courts where there are disputes. You know, our court system, the court system is not going to fall over themselves because UNRA has a case in court, no. So if there's a department whose sole responsibility and mandate is to acquire land for government, maybe then, because now they're concentrating all their time and energy on land acquisition, it may then be faster than where each government department is doing the land acquisition on their own. You have UETCL doing land acquisition. You have Ministry of Energy, the mainstream ministry. You have UNRA also doing land acquisition, amongst other things that they're mandated to do. And because you're not concentrating all your time and energies on land acquisition, the process may take a little longer. Also, if the courts are more supportive, there's a time. If courts are more supportive and would prioritize these cases, because these delays have a direct impact on the project. You've read headlines in the newspapers where UNRA is reporting that because of certain delays on the project, we're incurring a cost of 300 million shillings per day. Because someone has got an injunction from court, and once there's an injunction, work must stall. You can't do much about it. Or you had the famous case of that tree on the Busegampiji Road, a tree which was supposed to be a shrine or whatever. UNRA could not cut it down until the matter was resolved. Eventually went to court and sanity prevailed. And as soon as court ordered, the tree was uprooted. But before that, there had been a delay and the contractor was claiming money every single day. There's a time we tried to push through an amendment to the Constitution to allow for, the proposal was that if there is a construction project that is ongoing and someone's land has been assessed and valued, the value has been communicated to the claimant, to the landowner, and they disagree with that value. The proposal was that the executing agency should be allowed to pay the assessed amount as the landowner goes to court to contest that value and claim for anything additional over and above the assessed amount. And while that process is going on, the employer should be allowed to proceed with the works. That proposal was floated before Parliament. I think even the president had started going around the country trying to, sell it, but it was vehemently resisted. People thought it was a ploy by government to grab their land, and so it collapsed like that. But that would have sorted a lot of land acquisition problems. So we have a big challenge of land acquisition, not necessarily because there's inefficiency on the part of government, but from the nature of our land ownership law. We, as government, we are constrained in how fast we can move in acquiring the right of way. So there are bigger policy changes. So yes, discussions that need to be held if this problem of land acquisition is to be addressed. Otherwise, we shall continue to see government losing a lot of money as a result of claims from failing to grant access to sites. Thank you.
Thank you. Thank you for that clarification and well thought out answer. I think we are all well answered. I don't know that Edward Obo is still interested in speaking, because I see his hands up again. You can unmute yourself and speak. The admin on the other side, ULS admin, can assist on that. Madam Council Esther, before you go, someone seeks clarity on, you have talked about the dispute resolution clause, which happens to have several kind of areas within which parties can seek redress. She was asking her question is that, how effective have you been able to mitigate litigation risk by this kind of tiered kind of dispute resolution within FIDIC, in your experience as UNRA? You can unmute.
Sorry about that. No one ever wishes to end up in a situation of a dispute, and as much as possible, parties need to try and avoid getting into a dispute. Now, FIDI contracts, as I mentioned, allow for parties for amicable settlement of disputes at any stage of the dispute process. So parties need to take advantage of that. But it's also very, very important that communication channels between the contractor and the employer remain open. Very important. A lot of disputes are resolved because parties are able to sit, or disputes are prevented because parties are able to sit and discuss issues. So what happens on a project? You normally have site meetings happening. I think they're conducted as frequently as every week. There are site meetings, and at these meetings, issues are flagged. To say this is happening, these are the challenges we're experiencing, this is the kind of assistance that the contractor requires from the employer, and so forth. So if you have that kind of communication where you have these meetings, you're able to correct defects as they come up, together with the intervention of the dispute board. As I mentioned, the dispute board's role is not just to resolve disputes, they're also supposed to prevent disputes from happening. So they conduct periodic visits on the project, walk through the project with the parties, understand the issues of the parties, and then try and propose solutions to any issues that may arise. So all these things try and help to prevent potential differences from escalating into a full-blown dispute. So I would advise that the parties keep their communication open. Both parties have a common goal of seeing this project completed within time and within budget. That's the common objective between the parties. And that is what the parties need to be thinking about when these disputes are coming up. The contractor should try and avoid, increasing costs. The employer should try and avoid situations that would place the contractor in a position of making certain demands. So the employer has to do their part as well. If there are any challenges that either party is facing, they need to make this known to the other, so that together the parties can agree on how to address these challenges. If it's a land acquisition problem, for instance, the fact that I cited an example why you, for instance, have a 40 kilometers project, and then the employers avail 30 kilometers of a project and is unable to avail, say, 2 kilometers because there are disputes. That in itself may not necessarily cause the contractor to, ask for extension of time or cost. Parties may agree that the program can change. If the contractor had planned to work on a certain section, which section is encumbered, they can move and work on another section so that the contractor doesn't sit idle, and also the project doesn't lose time. So those discussions can be held. And in any case, there's even an obligation on the contractor to try and mitigate escalation of costs. So the contractor must do everything within their means to avoid escalating costs on the project. If it involves, changing the contractor's program, if it involves doing certain things, this must be done. As opposed to saying that, I had planned to do kilometer 10 and there's an encumbrance, so I'm going to park my equipment and sit and wait until kilometer 10 is cleared. Whereas you have kilometer 11 to 20 that may be free and the contractor may start work there. So it is not a rigid contracting environment in the sense that, parties can sit and talk and agree on the measures to try and avoid getting into a dispute situation. Thank you.
Thank you so much, Council Esther. We are grateful for the knowledge shared, the experience, and the exposure. It has been insightful. We are encouraged and have learned a lot. There is no amount of compensation we can give to you, but ours is that may the good Lord keep you safe and keep nourishing your knowledge and your health so that we can always perform it. We are grateful. Next is Mr. Milton Fedo Cheng. As earlier introduced, is a managing partner, Milton Advocates. He holds a master's in construction law and dispute resolution. He's also a board member of the National Building Review Board. He represents this section of the professionals, Uganda Law Society, and he's going to guide us through safety and health in the construction industry. He has a wealth of knowledge. Please welcome him and be guided by his experience in this industry. So as you can read from the screen we have shared, that's the gentleman before us. He's a good mentor and he has guided several that seek to survive in this industry. Please, Mr. Council Milton, come forth and take charge of your audience.
Thank you very much, Isaac. Just for test purposes, am I loud and clear?
Yes, you are.
Okay, first and foremost, allow me to apologize to all the participants and my fellow participants and all the other members on call attending to this. I had a technical challenge. Just as I'd spoken, then there's Zoom cut me off that my license had expired. You can imagine, but the devil is a liar. We will prevail. So I have no control over the slides. So I'll pray that whoever is managing it on the other side can be able to flip as we move. I'll probably be notifying the person that you can go to the next slide. So that slide there, as I can see, my CV is already there. Isaac has said a lot. Isaac, allow me to put a small disclaimer here that you earlier on made. We are all here to learn. Any presenter will tell you that they learn a lot from presenting, sometimes more than you leave the presentation more knowledgeable than you left it, because the participants are also practitioners and they're knowledgeable. So none of us is the alpha and omega of this knowledge. However, when you practice something, the same thing over and over again, you do get to master these things. So that's the disclaimer I wanted to put. There were several other questions of guidance. I think members can reach out. As Isaac have said, I think I've guided very many practitioners, and I've always said this: the more we are in this field, the better. Why? Because every time I'm handling a dispute, whether as an arbitrator or as counsel acting for a client, I want the other side to understand, such that you're not bringing basic contract law knowledge into the arguments that we're having in construction. Sometimes makes life easy for everyone. And then the more we are, the better. We are able to come together as members of this cluster and fight for business. I was happy with the Minister of Justice recently advertised and ring-fenced 2 big arbitrations for Ugandan practitioners. Of course, sometimes you can't do it without external support, but if we can take the lead in this and the practice grows more and more, we should also be able to bill government, which is the biggest employer, and clients, invoices or fee notes of $5 million, $10 million. Why not? If others are doing it. So thank you. Can we go to the next slide, which we're going to be looking at the presentation objectives. As highlighted there, we're looking at the categories of construction projects in which Occupational Safety and Healthy Act and regulations apply, the role of professionals, key hazards at various construction phases, legal requirements on all construction infrastructure projects, critical operations on construction projects. That is what we are going to be looking at. We can go to the next slide. Of course, we all know that the primary legislation is the Occupation and Safety Act. But we also do have building laws and regulations which govern building, for instance, building operations under the Building Control Act. So that will also come in, and I will explain why as you'll see later on, that certain standards and codes are part of this that are supposed to be enforced or applied in these building contracts or construction contracts with the objective of achieving a safe and healthy environment of work within the construction industry. And I must say that when it comes to building operations, National Building Review Board as a regulator, we always say safety first. Anyone will tell you safety first. It is only in Uganda, okay, it's only in Africa where we don't take safety so fast, but in other parts of the world, one fatality from a site can really cause a lot of problems. So those are the, so we have the Occupational Safety and Health Act. We also have the Building Contract and the regulations and standards. So the categories, you do have works of engineering constructions, which includes railway lines, construction, structural alterations, repair and demolition of the dock, harbor tunnel, all those. We also have the building operations and works of engineering construction, in brackets, safety regulations. It's more of a international standard when it comes to this, that do apply, and it brings categories of building structures, public structures and commercial, bridges, railways, tramways, highways, power generation and transmission, extractive industry where you have mines, oil and gas. Now the ECOP the project on ECOP is going on. That still falls under construction. So construction basically cuts across anything that goes into the soil and goes up. Most of it is really construction. We can go to the next slide. The next slide, basically, we are looking at who are the key players. As lawyers, you need to identify the stakeholders in the construction industry. So this table here illustrates to you who are the key players in construction. And what is important here is that all key stakeholders influence or affected by project safety and health. So it's important to recognize. So you have the clients or developer. In some languages, it's called the employer. And this is the biggest. This one always comes first. For purposes of road construction, my sister Esther is a very big client. There are no projects of roads bigger than the ones done by a UNRA as the employer or client. In that case, government of Uganda. You have authorities where you have Ministry of Labor, Gender, where you have Department of Occupational Safety and Health. If you're in this space, you always interact with them. There's a good lady there called Madame Eva. You have NEMA, you have the National Building Review Board, where if buildings collapse, we swing into action, but also we try before the building collapse. You have local governments, you have generally ministries, departments and agencies, you have project managers. Their roles are explained later on. I'll not spend so much time. You have designers and consultants, contractors and subcontractors. You have suppliers, like suppliers of construction material, where you have roofings, you have steel and tube industries, so many others. You have site workers, you have local resident users. And if you look on the right-hand side of that table, there are project stages. Where you see the black is where the influence or how that particular stakeholder is affected. For example, the clients and developer cuts across. The project managers, designers, and consultants also cuts across from briefing, designing, procurement, where my brother I have a lot of respect for has already discussed under procurement. You have the construction phase, which is the active phase. You have the commissioning, but also there's the post-completion where there's defects liability period and so on and so forth until final, until the project is, after the lapse of that time and usage and the rest. So let's go to the next slide. That is important. As lawyers, you need to know who are the stakeholders. These stakeholders are our potential clients, depending on whom you're working for at any particular time. Let's go to the next, please. The next, we have the construction project safety. Now, this table, the sources there disclosed. You are looking at ability to influence safety. It is much higher at the start if we dealt with safety concerns than later towards the end date. If you look at the start date towards the end date within the project schedule, you have conceptual stage of design, you have detailed engineering, you have procurement, you have the construction stage, and then you have the startup now. So you have design, construction, and maintenance, basically. So it is very important that we understand these stages. Now you see the curve going downwards. That explains the fact that at the beginning of the project, when we are at conception, Esther has already explained this. When the project is being designed, safety and health concerns have to be put into those designs. So that's, they are taken care of from the beginning. As we move towards the end date, detailed engineering, procurement stage, construction, there's the ability to influence safety slips away from our hands. So the next slide, this is basically to give you background information. Now here we start to bite into the real discussion. I do not know how much time I have, but I'll try to run through it. We have, as lawyers, it is important to know, it's important to know the role of lawyers in ensuring safety and health in construction projects. As lawyers, we are legal advisors. Isaac, can I be heard? Somebody is trying to interfere with this by calling me.
No, you are
okay, fine.
Yeah.
I'll just ignore the call. So we have the role of lawyers in ensuring safety and health in construction projects. First and foremost, we are legal advisors. So we generally know the law, we know the policy, we know the compliance issues, we know the regulatory framework issues. My brother has already talked about the ESHS provisions. We talk about the duty of care, negligence, breach of that duty. When does it arise? When does this duty arise? When does breach arise? Is it in contract or is in tort? In some cases, it will arise both in contract and tort. So this knowledge here as advisors on the project. And that is why when we are in this space, before a client signs or the contractor signs, these documents are shared. So to make sure all these are taken into concern. We shall see later on that this for example, standard form contracts like FIDIC, my sisters discussed. There are provisions, there are clauses within which, first of all, it is mandatory to comply. It is mandatory to comply with the law of that particular place. Like we've said, the FIDIC has international application and global application. So the laws sometimes might differ, but not so much. But there's a standard provision where you cannot, for instance, contract out these obligations relating to safety and health. You can't. And ignorance of the law, we all know, is no defense. And therefore, you cannot contract this out. So as lawyers, this is our role. Secondly, and broadly speaking, as draftsmen of these construction contracts, we are, first of all, what a contract does is to distribute and allocate risks. These include duties and obligations of the parties. We know the rule that applies to allocation of risk. You give a risk to a party who is best placed to manage that risk. So if you give it to another person, that is bound to cause problems at some point in the construction phase. So because we know the law, we now, as draftsmen of these contracts, now here we are dealing with bespoke or tailor-made contracts. Sometimes we are dealing with subcontracts between the main contractor, CCC, and another local contractor, let's say Build Plan, for example. When you're transferring, when you're doing these, when you're drafting these subcontracts, you must ensure that you're transferring these obligations and responsibilities too, because the main contract of works, for example, will be very specific, as we shall see later on. Not later on, I can actually deal with it now. That we'll see that these apportion responsibilities. When you look at standard form contracts, sometimes as lawyers, we're reviewing these contracts. For example, we have the local government PPDA contracts issued by PPDA, I think 2009. I'm not sure about the latest, but those contracts there. So when you look at those contracts, there are clauses in them. So we must be conversant with them. We must know them. If they are not there, as lawyers, we should be able to identify them and apply them. This is to do with local governments and government contracts. But if you're doing for outside governments, a contractor, Isaac, wants to build his big mansion by the lake in Chigo, comes to you and says, please do for me this. Symbion are my friends. Can you do this for me? So you'll have to know you have to, you may want to borrow from the standard forms and also put them in that contract to be able to address this, because generally speaking, the law distributes or imposes obligations and liabilities on every party in the construction cycle without really discrimination. Sometimes where there's a cause of action, everybody will be sued and then you sort out yourselves later. So to come back to the contract, what does the contract say about this? So for example, those PPDA contracts, when you look at clause 9, it provides for collective responsibilities between employers and contractors, collective between employers and contractor risks. When you look at 11, it's specific on employers' risks. In effect, it says that from the start date until the end date, until the defects correction certificate is issued, risk of personal injury, death or loss or damage to property, excluding works, plant, and materials and equipment, will be borne by the employer. And then you have a following, normally, the subsequent clauses on contractors' risks, which says the same, but includes works, plants, materials, and equipment. So that is an example of how that is distributed. When you look at that contract again, clause 19 says the contractor shall be responsible for the safety of all activities on site. The site belongs to the employer, but the moment the employer hands over the site to the contractor, that obligation shifts now to the contractor to make sure the site is safe for everyone. So that is just an example. Clause 13 will cover insurance. These are standard clauses. The contractor must provide insurance in the joint names of the employer and the contractor. Insurance cover from the start date again to the end date for events under the contractor's risks. So that includes issues of safety and health. For example, we can also look at FIDIC contracts. My sisters ably explained this, but just to highlight, you look at clause 1.3, compliance with laws. I already said that is very specific and is standard all across. Clause 2, for example, looks at the employer. Who is the employer? Clause 3 will look at the engineer's duties, authority, and instructions. We shall look more when we're looking at the next slide on the role of these professionals. Clause 4 will deal with the contractor's general obligations. Of importance, subclause 4.8 will deal with health and safety obligations. We may not go so much into deep with this, but I wanted to highlight. But what this provides generally is that the contractor shall comply with all applicable health and safety regulations and laws. That is subclause 4.8a. B will say comply with all applicable health and safety obligations specified in the contract. That means that in take care of all health and safety of all persons entitled to be on site, keep the site works where the works are being executed clear of unnecessary obstructions, as to avoid danger, provide fencing. You know, when you go to a construction site, you'll see all these notices for safety. You cannot cross this line, you have to wear a helmet, protective gear to the employees and what and so on, providing temporary works, including roadways. FIDIC is so elaborate. So if you really want to understand this very well, I suggest that you go and read subclause 4.8 of the FIDIC standard forms. Subclause 6.7 will provide for health and safety of personnel, which includes hours of work. For example, depending on the nature of the project, in the UAE, we have been so involved, sometimes projects work 24 hours because they are not challenged by finances and what and so on, because they do have a law that before a project commences, a substantial finance for the project financing is already in an escrow account. So when they start, they do not stop. So they even work at night in order to comply with the timelines within the contract and avoid the things my sister Esther was saying to do with liquidated damages and so on and so forth. So, but this is dependent on the nature of the project. For example, the oil roads, are built, some of them cut through the park. If you've driven through those oil roads, where, for example, worked with some clients, those parks are very, very dangerous. So safety concerns are very, very important. So when you look at any of the contracts for those oil roads, you'll find that UNRA as the employer was very, very specific. When you look at the employer's requirements, and you look at the technical proposals at the procurement stage for all those contracts, you'll find that safety and health was very, very important, because through the parks, animals can be a problem. So there must be provision of security, and in most cases, armed guards. And even now, when you go through there, you'll find where there are construction equipments and there are ongoing work at that particular point, you'll find armed men, either UPDF, or you'll find UWA, paramilitary people with guns there to provide security, because no one wants to be responsible for loss of life. So hours of work will be regulated depending on the nature of the project. Regarding the personnel, subclause 17.2, liability for care of works. That is very important. 17.4 deals with indemnity of contractors. 17.5 deals with indemnities by employer. And then 17.6 of that standard form deals with the shared indemnities. This provides for all those periods. So you also have, for example, clause 6.4, which I think I jumped, which specific on labor laws. This is one of the reasons why FIDIC is very, very globally accepted, because they're very thorough in their provisions. So this subclause 6.4 is on labor laws, which imposes on the contractor a mandatory obligation to comply with all relevant labor laws applicable to the contractor's personnel, including laws relating to the environment, wages, working hours, health, safety, welfare, immigration, emigration, and shall allow them all other legal rights. So that is for example. Allow me also, within the region here, for purposes of our discussion within the region, we also have the East African Institute of Architects Agreement and Schedule of Conditions of Building Contracts. It was a 1991 issue. It was reprinted in July 1998. This is what I know some buildings in this town, in this city, and within the region, Nairobi and Dar es Salaam, they've used this contract, even in Kigali. So when you look at clauses 18 and 19, they have provisions on injury to persons and people's properties, provisions for insurance under clause 19. I am just glossing over this under this standard form contract. Then you also have the, you have the JCT and the NEC. These are widely used in the UK. Somebody already asked a question about NEC, new engineering contracts. We already answered that question. Project financing, these international organizations are very strict when it comes to environmental, safety, health concerns. For those financing projects, in there are clauses which are very strict on safety and health within the industry. Also, as law enforcement agents, officers of court, in-house counsels of ministries, departments, and agencies, we represent contractors, we act for them. My sister Emily works with UNRA, so for that case falls under the first category. Myself and my brother John are on the outside here. So we deal with contractors, we deal with consultants, consulting firms, we deal with we deal with the project managers and as private practitioners. So we have a lot to do in ensuring safety and health within the construction sector. And there are many other avenues where we play a role to ensure safety and health. But also allow me say this, as lawyers, this is a low-hanging fruit. We have seen lots of accidents which have happened within the construction industry, building collapsing. So you need to, these are all opportunities for instructions and to also render a role regarding safety and health. So we do have, this is just an example, classified examples of where our role as lawyers, but we play a very, very, very good role in ensuring this within the construction sector, because contracts and so on and so forth in our different capacities, but also for purposes of understanding causes of action, negligence, when we are suing, we need to understand these, and we also play a role, even in jurisprudence, as lawyers, for example, those who are in the lower bench, the higher bench, those who are arbitrators. In your words, you're basically dealing with negligence, breach of duty, under contract, under tort. So these are words that you're writing, these judgments that have been writing, you're playing a role in ensuring safety and health, as I will quote from one of the recent decisions by Justice Sekana. So we can go to the next slide here. And I think Emily had touched on some of these. She was citing other laws which do applicable. There are the barrage of laws that apply to the construction sector. The construction sector cuts across every aspect of our lives on a daily basis, whether you want it or not. Of course, I've already said the Occupational Safety and Health Act is the primary act, and then the regulations made thereunder. We have the Building Control Act. And for the large part of the first term when of my service to the board, because we were given in 2018, when we appointed as a board, we did not have these regulations in place. We had nothing to use because previously we were still relying on the British standards and what we had to enact our own Ugandan standards. So you have those national building standards, codes 2019, for accessibility standards, postcode numbering, standards for electrical installations, mechanical installations. Why are these important? These are important in the sense that they provide, for example, the minimum standards that have to be used. And why are these laws providing for the minimum standards? To ensure safety and health. Because long after the contractor has built your house and gone, if the wrong standards were used, for example, buildings can still collapse. We've seen accidents of fires in these schools that have been investigated, and some of them because the electrical installations have been outdated. Because of heat, they catch fire, and accidents happen, and they are fatal. So these minimum standards are done. For example, the minister under sections, I think 42 of the Building Control Act recently issued a legal notice supplement number 9 of 2022 prohibiting the use of steel, timber and composite construction methods. Not because it is a bad method, no, it is a good method, but we do lack regulations in place. Anyone can just buy any size of timber, any size of steel, and just concrete mixes up and builds. So we need standards in place. So that prohibition is not intended to be permanent. It's temporal. As we speak now, regulations and standards for that particular methodology they're being developed. The board is interviewing players in the market, consulting with the architects, the engineers, and all these professionals within the building industry, so that we can be able to come up with these regulations. And we are working on them as we speak. This is information to you as your representative on the board. So where safety concerns, for example, that provision of the law gives the minister to prohibit any method which is not acceptable, which is likely to cause danger. These STC projects have collapsed. We've seen them. Because of time, I'm unable to share with you the pictures and what and so on, but several have collapsed because anyone is doing anything, regardless of the size, how high this building is going to go, what is its purpose? Because even designs are made to fit a particular purpose in a project. So it is important that we have standards in place to regulate this. So there are these laws here. We have the Physical Planning Act, basically to say, here we want industries, here we want a school, here we want this regulation of land use. We have the Public Health Act, which is directly applicable to issues of health and safety. We have the RTA. All these laws in one way or another do apply. I may not go much in details to break it down one by one, but they do apply. The next slide, we look at the role of architects, engineers, and project managers. Esther has explained this. I also explained a little where you have responsibilities and duties which have been distributed under standard form contracts and under the law as well. Those previous laws, some of them. For example, architects ordinarily design. Engineers also do design. We have structural engineers who come up with structural designs for purposes of, the load that the building is going to carry. They do the mathematics and they do the designs. So these people are very important. So in those designs, there should be, they need UNRWA projects. Sometimes they have project managers in-house, or they'll get a private firm outside of consulting engineers to do their supervision. That is a person appointed by the employer to supervise and administer that contract for works on behalf of the employer. So they have a lot of powers to issue instructions to comply with safety and health provisions. If you're not complying, for example, under FIDIC, there are notice provisions that do apply. If you do not comply within the time in the notice, they can escalate the matter and issue, suspension notices. And if you're really not compliant, can go all the way to termination. These are powers that the project managers have, all to ensure safety. Because when a calamity happens, it will be very, very, it will be regrettable to everyone. So these different people. So we also know that these responsibilities come with liabilities. Where you have a design responsibility, you have a corresponding design liability. Where you have a supervision responsibility, you have a corresponding supervision liability. There's also defects liability, where if something goes wrong, or the building or the road has not been done well, the employer can invoke some of these clauses. So all these professionals within this have a role to play in ensuring safe project designs and constructions, including overseeing management and conditions. The overall goal even at designing is to prevent any minor or serious fatal accidents, in these projects. Their actions or omission render the project's occupational safety and health system or program ineffective or effective. For example, I'm citing the example of the Northern Bypass here. When the Northern Bypass had just been done, most of the crossovers were lacking. So in some cases, you find the contractors tried to create natural steps by digging besides the road, so that people can be able to. But without those crossovers, people died, and perhaps they're still dying if they ignore the crossovers and decide to cross by foot. Because it's a high speed road, and therefore. So the omissions and actions are therefore very, very important in ensuring safety. I've already discussed. Allow me also make reference to we as a board, we've come up with the implementation guidelines. If you go on the website, you'll find them, June 2020. This is an implementation guide. It has the A to Z of building laws. All the regulations and standards are summarized there. We have a code of conduct and practice notes for construction sites. It's also June 2022. This basically, the building inspection booklet. So what we've done with this is that we have summarized and laid out tables. Who are the stakeholders that we already looked at? What does each have to do? What are their responsibilities? What are their liabilities under the law? It is all broken down there. For easy digestion and application by construction professionals. Standard operating procedures for building construction sites during the COVID time, all to ensure safety and healthy at that time. So we need to look at why occupational safety and health concerns in the construction industry. Here we are looking at images of this is one of the pictures of a collapsed. A retaining wall was being built, but it caved in and it was fatal. So here you start to see the roles of people. For example, wasn't there a design for this? Wasn't the design adhered to, or it was an omission? You look at this building on the right. Where is the fire escape in case of any calamity of fire? What about accessibility of persons with disabilities? These are all provisions of the law. What are the safety measures in place? If a fire started here, somebody will end up breaking a leg because we'll jump through that window. We've looked at, I've told you about the accident in Machindi. 13 fatalities took place. We remember the NSSF tower on Lumumba Avenue when the site had to be closed for several years. Esther will tell you how expensive it is to suspend or to bring a construction project at a halt. The contractor, if he's not liable for any reason, it is very expensive. Even if by the time you're sorting out issues of liabilities, somebody has mobilized equipment and what and so on site. At the end of the day, prolongation and disruption costs will be flying in people's faces to deal with. So it is important that this, I've talked about the school fires. In our homes, people have died from bathroom fatal accidents due to slippery tiles. A contractor puts the wrong tiles, which are slippery, not suitable for a bathroom. Yeah, it's stairs. People have fallen off stairs and sometimes fatal because of being uneven. The design is not well done. Either they are so steep where our mothers and fathers who have advanced age cannot even use them appropriately. Counterfeit construction materials. This is another thing altogether on the market. Some buildings have collapsed because of use of counterfeit materials that give way. When the materials are fake, they can't perform the purpose. Fitness for purpose test is failed. We can go to the next slide. This is just to illustrate to you why it is a very serious concern in the Occupational and Safety Act. Here, generally, construction works are one of the leading causes of industrial accidents in Uganda and the world over. It is a very serious issue. The construction projects bring together various multi-professionals and non-professionals, engineers of various specialties, civil, structural, electrical, mechanical. Construction projects sometimes can last for months, even years from conception to execution. We do know them. Even our own houses, we build them for 15 years. So we're also looking at the extent of occupational safety and health measures on a project are determined. What determines it? We have the nature of the project. How high is that building going? For example, that NSSF tower, which is going to be the tallest building, is going to be taller than the URA tower. The safety concerns are very, very important. Deep excavations, because it is going so high, we need to dig deep to have a very firm foundation as per the designs. For this purpose, we've created in those standards and regulations, when you're applying for building permits, we have class A, B, and C. And these classes, for purposes of building operations, are based on the complexity of the building. How big is this building? How high is it going? Even buildings in environmental, in wetlands, for example, that falls under class A. Buildings beyond a certain size, class A, you go to class B. C is basically temporary building operation works, which are simple in nature. I must also say that it is very, Esther will tell us, but I think accidents in road works are they're not so high as in building works. So the size and magnitude of the projects, area, complexity, duration of the project, the phase, ongoing works of the project, foundation finishes, level of safety and health, risks involved, depending on the particular type of project that is going on. Sometimes they vary depending on that particular project. So these are some of the examples of how these measures are determined. We can go to the next slide. Here we are talking about the uniqueness of the construction industry. Usually you'll find that there's no permanent workplace. Work is done in open air, usually exposed to varying extreme weathers, work done at great heights and deep pits, shafts, constantly changing nature of the building operations. This is ever changing. You know, the work sites are ever changing as work progresses. They keep shifting and shifting. Variety of equipment and processes involved. This exposes the personnel to high risks because there are so many equipments. You're down here trying to, to mix. If you can't afford the ready mix concrete trucks that just come, a crane is flying over, it is lifting weight. What if it gives way? Who is down here? All those concerns. The labor force can usually be recruited, which is unskilled. Migrant workers from large proportion of the workforce. We can go to the next, where we are looking at the key hazards at the construction design phase. We've already explained the role the designers play. Designers have substantial influence on overall project safety and health through systematic application of ideas, processes, and techniques. Let me also add that because the designers, most times, the designers are always contracted, with exception of design and build. But even in design and build, Esther has talked about the yellow book. Normally, people who have designed this, people who have designed the project will most likely supervise it. So they know what they designed, so they can also supervise to ensure safety and health. Examples of design risks to be considered and eliminated early in the project. Engineering is a science, and therefore some of these simulations are done to ensure that there's safety and health during the project execution. So simulations are done and run, very high unreachable ceilings for constructions. People have fallen trying to reach high ceilings in the construction industry, services or cleaning. This is even post-construction phase. So that design, once, the building has been built and, they've left, how do you clean? Burj Khalifa is the tallest building. How do they clean that glass there? So in the inception of the design, they must have made provisions where there are windows that should be letting people out with the hooks and rails, so that physically somebody can, get out there and is tied to a rail into the building to be able to clean that building. Slippery finishes in high traffic work areas, steep slopes of ramps, and even staircases. I've already discussed that. So at the design stage, there's what is called prevention through design. What does this involve? Explicitly considering safety of construction workers at design, being cautious of the building occupancy and how the construction will be undertaken, making these design decisions based on work processes to be done, including workers' safety considerations at that stage. This is at the design stage. So we also have at the procurement stage. My brother, John has already talked about the ESHS provisions. So during procurement, clients and consultants have the opportunity to ensure safety. We looked at the other graph at the beginning. There's more control to ensure safety or to influence safety at this stage of the project. So at procurement, for example, engaging contractors with the necessary competence to undertake the work in a safe, timely, and economic manner. You look at a contractor, their responses to bids, you look at the availability of safety and health equipment. Are they using, do they intend to use wooden scaffoldings which can break any time, or they are metallic? Which ones are the safest? Do they have gear? What is their track record? This can be achieved through a detailed pre-qualification process. Better contracting decisions can be made at that stage. Employers' requirements, technical proposals, I already mentioned that. Here, I am saying that world over, people are moving away from lowest bidding contractor or contracting methodology. This should be avoided because if you're going to pick a contractor at procurement who has the lowest cost, most times, first of all, he wants a profit on that project. Therefore, he's going to minimize costs. He's going to maximize. He's going to minimize so much that you'll end up employing people without giving them gears because they want a profit margin. But if we encourage best value contracting, which takes into account safety, record of contractors before awarding contract, this will be very important towards addressing safety and health at procurement stage. Because one fatality, depending on the size of the project, depending on the person who has died, it can be a substantial sum to settle in terms of compensation. Pre-qualification should be done, among others, by assessing the contractor's current and future commitment to safety. These are very, very important. Recently, we had a standoff with the ECOP projects. The reason for that is safety, because they're raising environmental concerns. The EU was raising environmental concerns. I know politics is also involved in that, but by and large, all these are intended to, to take care of safety concerns. We can go to the next slide. Still a continuation at the procurement stage. Environmental and social management strategies have to be in place at procurement. When the client or the employer is analyzing these documents, first of all, even before, when you're calling out for those bids, you want to know what the methodologies of work, what environmental, social, and management strategies as a contractor do you have in place to ensure safety and health? This should clearly stand alone rather than being embedded in provisions on sustainability, socioeconomic, environmental, and social responsibility infrastructure projects. In other words, they should be brought out very clearly in these construction documents. I am saying here that the aspects of OSH should be clearly captured in the site organogram, the method statements. This is where the contractor is explaining, how am I going to do this? The technical people with the employer or the client will be able to tell that this is safe, this is not safe. Mobilization schedule, construction schedule, specific obligations, and things like that. Requirements for health and safety specialists. On all those oil road projects, there was a requirement for environmental health and safety specialists to be on that, and the consultant must have had one, and there was even a budget to that effect to ensure that safety and health and safety was catered for on those roads. Esther was already explaining how some roads, some parts are going higher than the others. There was a time of these USMID projects. Whoever went to Mbale must have seen that for several months there was a standstill. The project was not going. The roads were done, but the shops were down. And all those are design issues, by the way, safety concerns, I'm also suggesting here that the PPE specification should be updated to address existing gaps so as to mainstream OSH requirements. There's a form A7 there on the legal status evaluation criteria and statement of requirements for companies bidding to provide supply. These should be, that there are gaps there that need to be filled in to be able to address this safety and health concern. We can go to the next slide. Looking at construction-related accidents. It is the next slide, 4.3. Are we there? Construction-related accidents, I think. Or it's slide number 17. 17, slide 17. Should be 17. Construction.
Yes, we are 17.
Okay. Construction-related accidents, preventing accidents and occupational diseases requires knowledge of the sequence of the causes before the necessary preventive measures can be correctly chosen, identified, and fully applied. So here we're looking at accidents at construction sites. How do they occur? How do they come about? Collapse of walls, building parts, stacks, masses of earth, soil, collapse and overturning of ladders, scaffoldings, stairs, beams, falls of objects, tools, and pieces of work, falls of persons from heights, high, off ladders, roof scaffoldings, during loading and offloading, lifting, carrying, and transportation, in connection with traffic on sites, all vehicles of all kinds turning around here and there. So there's need to have, normally on a typical construction site, the contractor, after taking charge of the site, is supposed to make provision for, where's the emergency assembly points, where do the workers be when they are eating, where do they, all this to address safety concern. Where is the machinery supposed to be parked? Is there enough space for it to turn, not to cause construction accidents? There's also in connection with dangerous gases, which are combustible, hot, corrosive, explosive materials, all those. These are causes of we can go to the next slide. These are all causes, key hazards and causes of defects in planning and organization. There are bullets there that fall under that, defects in technical planning, fixing unsuitable time limits, assignment of work to incompetent subcontractors. Every time you're subcontracting, make sure that subcontractor is competent, insufficient and effective supervision of the work. We already said the role that the consultants or the engineer doing supervision, they play a very important role. So where there is lapse in supervision, there are those problems, accidents are bound to happen, lack of cooperation between the different crafts and trades and professionals working there. Then there are also technical defects in methods and execution of work. Most of these disputes that come in construction industry go through arbitration. So we may not be so at liberty because it's private and confidential, but most of these, you find that there are technical defects. In some cases, a contractor proposes a methodology that is not working and causes accidents. So constructional defects, poorly constructed components, use of unsuitable building materials. I've already talked about counterfeits, defective building materials, and other defects. We can go to the next. Technical defects in equipment, where the equipment is not well maintained, where they're not, they're not suitable for work. It's bound to cause accidents. Lack of safety devices and measures, the protective equipment, management and conduct of work. These are different classifications: management and conduct of work, inadequate preparation or sequencing of work. In the construction industry, once S has already mentioned this, time is of the essence in construction. Therefore, a contractor will commit to a certain timeline that will start this project on the 1st of December 2022. In 6 months, will be done. Now, there's so that will the contractor will submit a program of works which is approved by the employer or the employer's representative. Now, that forms the critical path of the project. So there must be compliance to this. So this, if it is inadequate, then the contractor will try to rush through and accidents will happen. Safety and health concerns will be there. Dangerous acts and behavior of workers, basically being irresponsible, failure to adhere to the safety measures and health rules. This is part related to supervision, because the contractor, the law already distributed or allocated responsibilities and liabilities, unauthorized actions, carelessness, improper application of safety. We can go to the next one. Here we are looking at 4.6, we're looking at occupational diseases. It is important as lawyers that we know what are these diseases amongst construction workers. We have silicosis, which is a lung disease. There's a suggestion there for the prevention. We have lead. It's lead poisoning in paint, in painters. Those paints there, they have chemicals in them. They are harmful substances there, especially if someone wanted to increase their profit margin and went for the cheapest on the market. And again, talking about, government agencies have a cross-cutting responsibility in the sector. For example, where is National Bureau of Standards for these counterfeit paints and these harmful substances going on the market? We are all resident here, so we know what we are talking about. Sometimes a problem. So this causes these poisoning, diseases of joints and bones in workers operating pneumatic tools. So there are prevention measures which have been suggested there. There was a time I think I just started practice. There was a matter which came to me, and there's a lawyer called Robert. We eventually settled that matter because I told my clients that, there was even certification by the medical board, attaining the level of with an assessment of the disability and what and so on. So these are very, very important. So the next one, which is a continuation, we have skin diseases, which is called dermatitis. This one is mostly in cement workers. The prevention is there. Suggested poisoning by carbon monoxide and benzene. This is by combustion of carbon and its substances. There are first aid methods there. Recently, there was, not so long ago, there was an accident at Hima Cement Factory. I will not say much, investigations are still ongoing, but because Hima Cement is a child of Lafarge, this is international, is a multinational entity. They take issues of safety very, very seriously. I will tell you that heads rolled, people lost jobs because of that accident happening. So safety concerns are not a joke at all. So we go to the next slide. We're looking at still occupational diseases, hair impairment due to exposure to noise, and the prevention is also there. We can go to the next slide. Measures to address construction-related hazards. So we have technical measures. As lawyers, we're advising our clients to adhere to the laws, recommendations, regulations, design standards, appropriate material specification, correct application and use of appliances, equipment, and structures, provision and correct use of safety devices. That is at technical level measures. Then we have organizational and administrative measures. Policies, plans, procedures, and programs for safety and health are very, very important to be adhered to. Some of them are international, some of them are local, to ensure safety. I'll tell you, for example, the International Building Codes prohibited the use of guardrails in the construction. When you use guardrails in horizontally, it has been determined that they're likely to trigger a ladder effect for the children. They want to climb on them to go to the next higher level. Before you know it, a child falls and dies. That's the safety and health concern. So right from the design stage at a technical level, so at a technical measure, you use the right designs and avoid these things that will be policies. Very, very important. We do have the occupational health and safety management systems. They're quite expensive, but for contractors who are doing good subject matter construction projects, it's important that they apply these occupational health and safety management systems. So they provide for management leadership and commitment, safe work procedures, written instructions, health and safety training and continuous training and instructions, identifying hazards and managing those risks is very, very important. Competent supervision is very important, instructions and so on and so forth. That is at an administrative and organizational level. So let's go to the next slide. As lawyers, we're looking at legal requirements. So I already said that General Occupational Health and Safety Act provisions under Part 1, 2, and the rest. You have those. You have a summary there. Parts 3, 4, and 5 deal with general duties, obligations, and responsibilities of employers. These are the same as you're dealing with employment issues of occupational health and safety. The same laws do apply in the construction industry. I've already emphasized that the other side that earlier on that we have the building standards, which are more technical in nature. If you use a steel bar of this strength, of this size, use electrical cables that can withstand current of this magnitude, and so on and so forth. So the legal requirements are there. At your free time, you can get time and go through the registration of work, but I'm sure we are familiar with these registration of workplaces and so on. Mostly in this area, you're dealing with that Department of Occupational Safety and Health within the Ministry of Labor and Gender. But the board, National Building Review Board, is also very, very, very much at the forefront of ensuring safety and health that happen. There are offenses and penalties that do apply. We must ask ourselves, of course, are these penalties sufficient? These currency points, are they sufficient enough? I think we need to move towards making it, payment of very, very high costs, whether financially or otherwise, closing your site and all these things to make sure that we put safety and health in construction at the forefront. Because even when you're advising contractors, if there is no adequate financial backing or measures in place, fatal accidents can wipe off a contractor if you go into compensation as a result of fatalities. We can go to the next. Okay, there we are. Occupational safety and health, building operations, works of engineering, construction. So this is, I already mentioned this earlier. It's called BOEC, the Building Operations and Works of Engineering, Construction, Safety Regulations. Part 1 is dealing with the application, interpretation. Part 2, general construction, design and management duties. This will go to the designers of construction projects, whether buildings or road, whatever it is. Competence, cooperation, and coordination. What are the client's duties? Just like we discussed the the sub clauses, for example, in a standard FIDIC contract or PPDA contracts. These also, they speak the same. What is the employer's or the client's duties? What are the duties of the designers? Duties of contractors and those who are subcontractors, self-employed, and so on and so forth. The coordinators, supervisors, consultants, spells them all out. So when you're drafting a contract, for instance, you can always look at this and borrow and put them into your tailor-made contracts that your clients instruct you to do. We can go to the next slide. These are special rules, the same as the other, but these are special rules. Part 3 basically dealing with health and safety on construction sites. Like we already explained earlier on, you're looking at work at what height, raising and lowering, lifting machines, appliances and gear, deep excavations or any sorts of excavations, demolition works. And for purposes of the Building Control Act, most of these are classified as building operations. And you'll be shocked that you actually need permits for them, including demolition, excavations. All these can be taken independently. So that's what is the objective of that? So that when you submit your application for this building operation permit, let's say demolition, KCCA, for example, will be looking at the building control, the building committee of KCCA will be looking at is the methodology right? Aspects of safety and health being catered for to avoid liabilities and so on and so forth. Site transportation, is hazardous materials involved depending on the nature of the project, hierarchy of controls, health and safety, welfare on site, fire and safety. We've had lots of fires in this country, especially schools. Some of them we've investigated, we found them to be arson, but those are limited cases. The majority of them are a result of poor or non-observance of health and safety on either sites or already used buildings, and also the lack of the maintenance. We can go to the next slide, 7.2. Continuation. This is I've summarized the miscellaneous safe places of work, site organization. How should it be? Protection from falling materials, loose materials, construction of temporary structures, avoidance of danger from collapse, and so on and so forth. Electricity. You'll find that at most sites, the site may not be fully connected to MEME, but there are wires running around because the contractors, the builders are grinding, they are cutting tiles, they are cutting walls, and they're using all these machines. So wires are just running around, the site, and that exposes workers and everybody else who is on site. Energy distribution installations, preventions of drowning. I note here that the regulation is being amended to incorporate responsibility of all the other stakeholders in construction, including clients and developers, because that's a gap that has been identified. We can go to the next slide, which is 8, construction phase safety and health plan. What should be embedded in this document? As a lawyer, you'd not be surprised if a player in the market comes to you and asks you, and that's a rationale for including these things, can you do for me a safety and health plan? Yes, there are experts who are non-lawyers in this, but as a lawyer, you're a draftsman. So they'll come to you and ask you that, can you do for us a safety and health plan? And these are mandatory requirements. My brother John did talk about them in procurement. They will ask for these documents. They will ask for these policies. We are doing some work with some people, some corporations in the Tilenga projects, and some of these they take very, very seriously. So those policies are drafted by us, the lawyers, because our background is legal in nature, and compliance with the law is the first rule. So they don't be surprised if somebody came to you and told you, draw for me this, so what should be included in this? I endeavored to include this for your own benefit, that, we have the statement of safety and health policy, project planning organization, administrative controls in place. Some of them are operational procedures and practices, stage by stage for the project, risk assessment and mitigation measures, safety and health site rules, they must be there. Plan and equipment operation and maintenance procedures, safety and health signage schedule. We've gone to sites, we've seen these, there are safety method statements for all major operations, what happens in case of an emergency, an accident occurs, and so on and so forth. They must be very elaborate and outlining everything, baseline and proposed hygienic surveys and measurements among others. So we go to the next slide. Here I've endeavored to summarize within the construction industry, which are the which work processes are considered very hazardous, and they normally require specific risk assessment, safe work methodology statements, and a permit to work, demolition, excavation, and earthworks. For example, in building and even roads, in some sections, you'll require geotechnical surveys to be done, investigating the subsoils. Esther has already talked about a clause in the FIDIC contract that relates to unforeseeable events or occurrences, which sometimes the contractor wants to claim as a compensation event. Even our local PPDA standard form contracts do have them there. So some projects will require that you do subsoil investigations, which are geotechnical supports, so that these can be taken care of. Very, very important that those are done. Work in confined spaces, concreting and related operations, hot works, welding, flame and cutting. This is happening. This will happen, or it's already happening a lot in the ECO project. There's a lot of welding involved, and they're welding using gas, highly combustible. So safety and health is very, very important. Painting, working at heights, assumptions should be made. What if somebody slips and wants to fall at those high levels? Is this person protected? Are they having some strings attached to them as they're going up? Stacking and storing, and many other examples are considered very, very hazardous. Well, let's go to the next slide. Here we are looking at challenges to enforcement. As a National Building Review Board, we're not doing very well when it comes to seeing prosecution being done. Of course, I want to say this very respectfully to my colleagues in DPP's office and the DPP herself. Sites have collapsed, investigations have been done, files have been forwarded. But again, as lawyers, we representing our clients, the first thing in these cases, we want to see how do we sort out these issues before somebody is charged and what and so on. But anyway, the enforcement in as far as prosecutions are still very low. The Minister, General Katumba, is very serious about this. If you talk to him, he knows these accidents within Kampala and outside. They're on his fingertips. He knows that they disturb him. And it's very difficult to explain when a building site, there's been an accident and he has gone fatal. So we need to work together on this, even as lawyers in private practice, to ensure that, we enforce these laws and regulations. Of course, limited funding and facilitation. Sometimes these investigations are very technical. Issues of capacity of investigation. We have the National Laboratory that investigates construction materials, but the capacity, 45 million Ugandans. So for that, we've secured funding, and we are building a national building research and laboratory in Luvoa that is going to have a state-of-the-art equipment to do these tests. Because as a lawyer, you need, even when whether you're prosecuting or defending, you need expert reports regarding, for example, a collapse. When a site collapses, there's a technical team that goes on site and collects samples of steel, of the cast concrete, reinforced concrete. They test them to see, do they pass the minimum standard? So we are doing that. The other thing is lack of information. There's no data. So or poor management of that data. So the research center is centered towards being a research and development center where we are collecting data and storing it for usage for purposes of enforcement, and also compliance, institutional challenges, collaboration and contradiction, interference, in quotes, Gambanogu is a very serious issue in this country. Mandate overlaps, developer fatigue, and so on and so forth. Low staff morale. These are highly summarized for purposes of this discussion. I'm trying to run through and conclude because of time. The ones we're looking at were internal. So we also have external, private developers wanting to cut costs and not involving professionals in their undertakings. The contracts will provide for contractor undertakings that they must that contractors must make. Those feed each contracts, the PPDS, the undertakings which are a part of the employer's requirements and technical proposals. They're very, very important. But you find that after somebody has signed the contract, they start cutting corners. They want to avoid using professionals because they want to use as little money as possible. Some big multinationals, and I want to say this very respectfully, and more subcontracted local firms stop on refusing to pay attention to matters of safety and health. We are reactionary in nature. We want when a building has collapsed, that when we start swinging in action. But the overall should be avoidance. Double standards by investors. Some of them want to flaunt the labor laws. Some think that money can buy them everywhere. Hazy collaboration between institutions. These are government institutions, urban and local authorities. You find one denying a building or construction permit, the other one, authorizing. So all those inconsistencies and lack of collaboration. I've already talked about National Bureau of Standards, counterfeits on the market. Where are they? Immigration and customs. These things are crossing through our borders and are coming in. We are almost becoming like a dumping site for these fake materials. So where are these government entities, the MDAs, local and urban authorities? Where are they looking? We need to work together, collective responsibility to ensure that we address these challenges of enforcement. Non-decentralization function due to professional competencies required. The last time I checked, we didn't have more than 250 architects this whole country. Now, these are people who are designing projects, they're supervising. Most times people are holding out as architects. Ask them properly. Or go to their respected professional registration body. You'll find that they call them what? Drafts something. They have diplomas in drafting and what and so on. So professionals are lacking. Engineers are few in this market. Most of them are quack. That site that collapsed in Makindye is a senior 4 dropout. And that gentleman is saying, where have you people been? I have over 100 sites in Kampala. So all those, Juakali, some things become technical and they overweigh them. So wrong perception, attitudes and cultures of the people. We normally want a problem to happen. That is when we can be able to. So here, the endeavor to share stakeholder or shared collective responsibilities. Government is short-handed and under-resourced. Definitely. If I told you the budget for the National Building Review Board, it's very small compared to the regulatory work that you have to do across the entire country. Inspections are very difficult. Let's, by sample, how many construction sites are happening in Kampala? Does the board have the capacity to be everywhere? It is impossible. Even implementers like the building committee or local governments, KCCA, inspection department, they cannot be at every site. They cannot monitor what is happening at every site. Well, the regulations now make it mandatory for every building owner or client to employ professionals, but there are also not very many. And it comes at a cost because it's highly specialized. So we need to have shared or collective responsibility, all stakeholders to be eyes and ears on the ground of the government. Let's be our brothers' keepers. If you see a site is ongoing, there are toll-free lines for the National Building Review Board. You call. Some have abused it because of misunderstandings with neighbors. They call. And when you go there to investigate, the team always finds that I think it's just there are some personal issues between them. But if we utilize these methods, available forums well, we'll be able to reduce the building accidents and accidents within the building and within the construction sector. Professionals to spearhead and drive, learn about and apply legal requirements of health and safety. We come at the forefront as lawyers. In one way or another, we are lawyers to either a contractor or an architect, a consulting firm, lawyers to governments. We need to spearhead this, and we do our best. Then collectively, we start seeing some changes. Employers, developers, and consultants, contractors to facilitate sensitization, capacity building of workers, to recognize their rights and obligations, hence change their perception about health and safety. We can, even as lawyers, we can, as more society, we can, the construction law cluster can start having a drive. We can write a good paper and even get funding to sensitize masses in different places about their rights and obligations regarding health and safety, and so on and so forth. Use of occupational health and safety management systems. Some of them are international, the ISO standards, and so on and so forth. These are very, very important to combat. Can we go to the next slide? This is my conclusion, really. Lawyers, engineers, project managers, generally everyone in the construction, every construction professionals and developers, we should take the lead, to uphold the standard and duty of care in occupational safety and health compliance in the construction industry if we are to achieve safer construction methods, because these accidents are fatal. Could be our mother, our father, or anybody else, somebody from our families. So we need to be serious about that. You realize that in this discussion, I've not discussed a lot of cases, but there are wealth of authorities out there on safety and health where people have been sued. Some of them are settled, but also because by their nature, for example, standard construction contracts, whether PPDA or FIDIC or NEC or JCT, by default, the dispute resolution is arbitration. And so most of these do not become of record because of that. But also in our national courts, we do have so many cases of accidents from building sites, electricity operations, and so on and so forth. Here, I just found this interesting, and I'm sharing the quote from Justice Sekana in this case. This case was, it passed this judgment recently, in or about August 2022. It was making a policy consideration by the judiciary that this court would not encourage reckless and hazardous as well as economically inefficient behavior on the part of defendants in bracket contractors, but for this purpose, read all the other professionals, as this would appear to condone unskilled personnel in the construction industry and might lead to loss of life and property in future due to collapsing buildings in Uganda. For me, it is the judiciary making judicial notice of the accidents, collapsing buildings in Uganda. It is no longer, tenable. It's no longer acceptable that these accidents should continue happening. And we should be very passionate about safety and health. So there are wealth of authorities that deal with this, but mostly this basically you're discussing. For example, in this case, there was no accident, but what is important is this emphasis of safety and health, use of professionals, skilled people, personnel, and these skilled people must be adequately provided for, observance of their hours of work. Anybody, naturally our bodies give way. If you let somebody work for more than the appropriate hours, they will fall off and sleep. Policy matters of safety and health. The project of the I've already told you, the oil roads, because it is in a park, you don't want darkness to find workers on the road. So work must or used to stop very early, so that people can be able to move back to their camps, to their bases, so that before it becomes risky. Works of bridges, the Nile Bridge, work would end early for safety concerns, because if somebody falls down there, the person is gone. But nonetheless, there should be mechanisms, response teams on site and so on to save lives. Life is very, very precious. And that is why the end of this is that no job is so important, also urgent, that time cannot be taken to do it in a safe manner. Safety, safety, safety is very, very, very important if we are to move forward. Yes, as lawyers, we get instructions, but we can get more instructions when we are focusing on avoiding fatal accidents happening and making the construction industry a safer place. And we will all have more and more business to do. Ladies and gentlemen, thank you for listening to me. That brings me to the end of this discussion. Thank you very much. Over to you, Isaac.
Thank you, Council Milton. You have clearly given us a full course on occupational health, and we are very grateful for this. We, as earlier said, there is no amount of money would easily pay our panelists for the knowledge they have shared, how insightful it is, but I'm also mindful of the fact that this happened a bit on the short notice. For those of you who don't know at this end of the planning, some of these people are called up on short notice, but because they are passionate about this sector, they want to share knowledge and get others on board. They have labored to deliver, and we are grateful. Thank you so much. May God grant you your wishes, all our panelists, for the experience, the exposure you have given us, as we also grow in a career and also improve as we provide legal service to our clients. Clearly from your presentation, Milton, it has actually enlightened the fact that occupational health and safety is not a one-man show. It's a process that starts from the inception of the project, even actually from the visibility study, whether we should start off any project, construction project, up until it's finished, and then we even get into the lifetime of the project. And safety is the lifeline of any construction project. Without any project showing that shall be secure to its end user, then there is no relevance in having such a project. So thank you for that highlight. You have quoted a number of laws, which I'm certain many people could be seeing for the first time. And let's labor to get ourselves exposed. I'm seeing a lot of thank you messages in our comment section. It has been enriching for the lawyers. And we also request for questions, even though we undertook by 2. And that we shall do. If you have any question, please ask. On the question of presentations, these are going to be shared. ULS, our program leader, Doreen, and her team, Ken and the others, are going to get back to you because you're ULS members. Your emails are well known, through which you logged into this conference, online conference. You'll be given notice. So the panelists are not solely responsible for sharing. It's our entity, ULS, that will share, but they have done their role to share them with the 1 hour coordinator. So just give it time. It could not be done instantly, but they are coming. So be confident of that. We thank you for the time you have put in, the resources you have invested. So in case of any question, we have a few minutes to attend to you. Please ask our expert panelists. They are all still online, and they are putting a lot of their time to guide us so that we are knowledgeable in this area and we take on instructions with confidence. Someone is asking, and this is for Milton, in a few minutes, with your practice, please guide lawyers, how can they best interact with the National Building Review Board for beneficial relations with the board?
Thank you very much, Isaac, for that question. It's how can lawyers do what? Just repeat it for me, please. It's on the chat
Interact.
or
No,
Q&A.
the
Hey, interaction.
with
Oh,
the
sure.
building
Thank you.
review board. Oh,
Thank you for asking that question, participant. One, you, as your representative on that board, I would be very, very happy if we increased participation of members of Uganda Law Society with the board. It would be something very good, because then we need to be able to understand each other. Before I answer the question, let me tell you that, let me share this, that the board has received, I don't sit there on a full-time basis, but the board has received several notices of intention to sue. Yes, the board is a regulator, but also you cannot, I've already discussed the inadequacies in government funding, the limited resources. You cannot be everywhere. So those notices of intention to sue are premised on the fact that the board is a regulator, and therefore, if a building is collapsing, then somebody is not doing their job. A generic cause of action. If we had more engagement together, I would love to see those notices of intentions abandoned, so that we work together. And that leads me to your question. We do have a secretariat, which is on Lumumba Avenue. It is next to that new tower that is coming up for NSSF, the NSSF Pensions Tower. It's on the second floor, Rumi. Reach out there, go to the reception and say, introduce yourself, I'm a lawyer, I want to know more. There's material, printed material that they will give you. These implementation guides that I've shared with you, the building inspection booklets, and all these are there. But also, that is physical interaction. You can reach out to me if you need anything specific, but generally there's that secretariat, it's a public office. Walk in there, somebody will attend to you. There's a toll-free line. Do I have it off head? It's a 0800 number. I don't know, maybe I'll find it, but it's on the website as well. There's a toll-free line, just call. Somebody's there 24 hours to pick that phone and take your concerns if you have questions or anything. That's another way. The website is also there. A lot of these materials are there for your learning purposes, for reading. These are public officials. Reach out to them, talk to them. But I think we need to have some more engagements, maybe as a board and Uganda Law Society. One of the things that I would say is that we've discussed amongst us as panelists, and Doreen, who heads the continuing legal education department, we need to see more of these trainings taking place. So in these trainings, we should be able to have one special one with the board as members of Uganda Law Society, and we understand each other and discuss. All these are ways of interaction. I don't know whether I've done justice to this question.
Yes, you have done justice to the question, and we are running out of time. We have more or less just 2 minutes. What you said is applicable to the question. I would also want to report that yesterday, as closing over Twitter, I got to see that the Building Review Board will be launching something called BEAM, which is like an online management system for a lot in Munyonyo. So I think they are doing a lot to improve the sector. Without going far and wasting
Isaac, if I may just say something about that. Thank you very much for that information. Yes, tomorrow the Building Information Management System is going to be launched. We were expecting His Excellency to come, but most likely he's going to send the General Minister Katumba. But what BEAMS basically does is that we've developed an online platform to, we have issues of corruption when it comes to processing of permits. So this is an online platform that you interface without really knowing who is on the other side. You submit your application for building permits online, you pay, get a PRN number. All this is to increase efficiency. So it is also interactive. You can ask questions and somebody will attend to you and answer those questions. So what BEAM basically does is it does many things. It is integrated to the Lands Ministry. and all these other government entities. Therefore, it's hosted by NITA-U, so it gives a lot of access. And that launch is taking place tomorrow. And in developing it, we're also looking at the laws and regulations to make sure that it is not just an e-platform, but is compliant with the law as well. So Isaac, thank you for that note.
Ladies and gentlemen, that is enough for today. Thank you for
We don't
your
have any
time.
questions, Isaac?
We don't have any questions. It's
Okay.
just one person who had reached out. Even in the Q&A, there are no questions. It shows the in-depthness of the paper presented, and people are thankful. When you look at the chat, it's all thank you. So, these panelists, thank you for your time. We are grateful. We hope next time you'll be available to guide us further and better. We shall call it a day. It's okay. You can log out. Thank you for your time. Have a good day. Bye-bye.
Thank you.
Thank you, John. Thank you, Emily. Thank you, Isaac. Thank you, Doreen.